All right, welcome back, everybody. This is, let's see, we're on number 4 now, right, Rob? Series in our series on licensing law and rules comments. We're breaking down that section as it is such an important section, something that you will be tested heavily on both here in the course as well as at the state level when you take the state licensing exam. Again, a series of videos that we are taking some time to break down further the licensing law and rules comments, part of the Appendix A for those of you at the Go School. That textbook has an Appendix A that we emphasize so strongly. This is what we're talking about. So in this episode, if I may, number 4, we are going to, or before we go further, let's recap where we were. Wouldn't you say is a good idea, so that anyone that's just joining us at number 4 will realize what they might need to go back and look at in number 3. So in our last video, we were talking about the North Carolina Real Estate Commission, NCREC. That is, again, the governing body of all licensees, including schools. And so we broke down the structure of NCREC and, more importantly, what they can and can't do. And I want you to think of fines versus reprimands, those types of actions that can and can't be done by NCREC. And then we got into a lot about one of the most important disclosures that's required by the North Carolina Real Estate Commission, and that is what we refer to as the WWREA, the Working with Real Estate Agents disclosure. Hugely important topic there. Again, heavily tested. Make sure you understand that disclosure. We then got into some general license provisions. We touched a little bit more on agency. Again, these terms of agency, dual agency, designated dual agency should all be on your mind. And then we ended with some prohibited conduct under NC licensing law. We're going to continue with that here in series number 4, video number 4, that is, as well as we're going to talk a lot about contracts. Again, a kind of a little bit more deeper dive into, or we've pulled out of, what unit is contracts in, Rob? Is it 8?
Unit 10?
10, sorry.
Oh, you know what? Depends on the contract. Unit 8 is agency. Unit 10 is the offer to purchase.
Okay, so we're going to take some more stuff out of those units that you've already had and really focus in on how they apply under licensing law. So again, contract section, the do's and don'ts. We're going to also talk a little bit about advertising do's and don'ts, right? Some important factors there when it comes to advertising. And then we're going to end on some information you need to know about the Timeshare Act, North Carolina Timeshare Act. And then we'll conclude our series today with a series of rapid fire quiz questions, kind of an all-inclusive review of our series. So let's get started with continuing on with some of those prohibited acts, specifically the discriminatory practices. Rob, tell us a little bit about discriminatory practices.
Sure. So specifically here, we're looking at fair housing laws, and there's an entire unit, very important unit in the Dearborn textbook. I want to say it's unit 19, 20, 21. I can't remember exactly, somewhere around there. And it's fair housing. You can find it. It's in the Dearborn textbook. Forgive me for not memorizing it, but it's incredibly important. It's probably worth, eventually Jason and I doing a video just on that, because it's super, super important for your exam, super important for your career. But essentially it talks about, among other things, federal fair housing laws and North Carolina state fair housing laws. They're quite similar. Most of the violations or the prohibited acts are going to be the same, but there are a few that are different. So it's possible that you could violate North Carolina state fair housing laws, even though you did not violate the federal fair housing laws. For example, federally, a for sale by owner is, although no broker involved, but a for sale by owner federally is allowed to, I hate to say they're allowed to discriminate, but they are allowed to be a little bit selective in terms of who they sell to. For example, of course, they can't base that determination on race or color, because that's protected under the Civil Rights Act. but they could say, well, a for sale by owner, and maybe another state may say, I don't want to sell my property to a family with children, or I only want to sell my property to a family with children. So that's a protected class, familial status. Now, in some states, from a federal perspective, they may be able to be selective on that. But in North Carolina, we say no. We say for sale by owner does not get any exemptions, right? So a for sale by owner is not allowed to make a determination on who they're selling to based on a protected class. And you can go look up the 7 protected classes. They're in the Dearborn textbook. You could Google them. They're pretty much been the same for the last 40 years, give or take.
Yeah.
And so close to 40 years, with a few modifications in the last year, but mainly they've stayed the same. And so there is a difference between federal fair housing and North Carolina state fair housing. If you violate the North Carolina State Fair Housing Act, it is considered improper conduct. And not only could you find yourself in hot water with the North Carolina Human Relations Commission, who are the people who investigate these fair housing claims, but you could also be investigated and quite possibly, I would say almost definitely, if you're found guilty, disciplined by the North Carolina Real Estate Commission, because violating fair housing laws is in fact a violation of license law as well. So they just like to point out that, yes, if you, let's say, refuse to work with someone based on a protected class and you're found guilty of violating North Carolina state fair housing laws, that's also considered a violation of license law, and you're going to be held responsible to both the Human Relations Commission or committee. I'm not exactly sure what they call themselves, committee, commission, but the Real Estate Commission will definitely hold you responsible as well.
Yeah, that's one area that students get confused, understandably so. Again, the differences between the state versus federal, and how there are some additional restrictions on perhaps the state side versus the federal side, or vice versa. And so this is going to really come down to reading your test questions carefully. And again, knowing the differences between these fair housing guidelines and laws and acts, such as, again, the NC State Fair Housing Act. So yeah, be very discerning between when reading these questions, as far as what is it really asking you, and knowing, again, the differences between state and federal is going to be crucial, right?
Right. I always encourage students to think of what I call the big 3. You've got, of course, the Civil Rights Act of, I want to say 1866, which was the first civil rights law. It prohibits discrimination based on race or color, and the sale or rental of real or personal property. So that Civil Rights Act of 1866 applies to real estate. It applies to buying jet skis. It applies to renting a beach house for a week, all that stuff. That's 1866. And then the federal fair housing law was created in 1968. That covers the entire country, and that has those 7 protected classes. And then I want to say it was early 80s, the North Carolina State Fair Housing Law was passed. The good news is most of these big 3 are the same, but there are some subtle differences. And I highly recommend you understand those subtle differences, because they can get a little tricky on the test in terms of which one was violated. Because it's possible, let's say, for example, if somebody is discriminatory with a sale or lease of a commercial property, that doesn't fall under fair housing. That has nothing to do with fair housing laws, but it's quite possible that they may have violated the Civil Rights Act. And so it gets a little bit tricky there with regards to which law was violated. So I go back, remember the big 3: Civil Rights Act of 1866, federal fair housing laws, and North Carolina state fair housing laws. So if you can spend some time understanding the similarities and the differences between the 3, I think it'll really pay off for you.
Great. And I can confirm it is Unit 19 in our textbook, Unit 19, that is a big focus on what we're talking about here. Very well. Let's move on now to, a lot of times it seems as though, from the student's perspective, that you guys are we are teaching them to be a lawyer.
Feels like it.
It seems like it, right? Because we're talking about so many laws. I mean, heck, even the series we're doing right now, we're breaking down the license law and rules comments. But it's important to make a distinction, right? That we are not lawyers. I wish it were as easy as taking a 75, 85-hour course and passing the bar, but that's not quite what we're doing. So in addition to remembering that we're not lawyers, what does that entail specifically in our world?
And this one can be dangerous, really, because you're going to eventually find yourself as a practicing real estate broker, you're going to find yourself staring down the temptation to just, we can't find the contract or the addendum that kind of scratches our itch here, that does what we need done. So I'll just write it. I'll just sit down, I'll break out my Microsoft Word and I'll write this thing out and I'll put in a place for the seller to sign and the buyer to sign and we're good to go. Well, the problem is only an attorney can draft a document that is legally binding on other people, right? So that's the key. In order for a document to be legally binding for other people, it needs to be drafted by an attorney. And so we cannot draft contracts, leases, deeds of trust. I mean, deeds and deeds of trust are fairly obvious. That's the lawyer stuff. But where we could get into trouble is thinking, well, I got this one property that I'm managing on the side. Why don't I just sit down and write up a lease and I'll have the owner sign it, and I'll have the tenant sign it, and we'll all live happily ever after. Well, the problem is that's illegal. That's the illegal practice of law, and you could find yourself in trouble for that. So the term they use a lot is drafting. I always say leave the drafting to attorneys and race car drivers. Brokers should stay away from it, right? Stay away from it. And they love this term instead. Instead of drafting a lease or drafting a contract or drafting an addendum, what we do is we fill in the blanks of approved pre-printed real estate forms, right? I cannot create a lease from scratch, but I could take, let's say, the North Carolina Association of Realtors lease, and I could fill in the blanks. I could fill in the rental amount. I could fill in the expiration date. I could fill in any other terms that already exist, but I cannot just sit down and write a. And I always jokingly say, you never hear, and Jason hears this every day, and Jason and I high five our colleagues because what they say is, hey, Jason, I'm writing an offer on your listing over there in Apex. And Jason's like, woohoo, that's great. And I'm like, what you're really doing, because I don't want to be the grammar police. What you're really doing is filling in the blanks of an offer on Jason's listing. You're not writing it. You're not drafting it, but no one's going to say I'm filling in the blanks. They say I'm writing an offer, and that's great. That's fine. But keep in mind, we are not allowed to actually draft the contract from scratch. We just fill in the blanks of what's already there.
Yeah. And that would include like emails too, right? Like sending an email to an agent saying, here are the terms that we want to make legally binding.
Correct.
Or text, like here are the terms we want to make legally binding. Yeah. Fill in the blanks on an existing pre-printed real estate form, or have an attorney draft that form or contract that you decide to use. So I would say to our students that when you see in a multiple choice question on an exam, one of the multiple choice options, including the word drafting, that should stand out to you. If it says something to the effect of just have the real estate licensee draft up something, or something like that, then that is not right, because we cannot do that. We are not allowed to draft any type of legal document like that. That's not what we do as real estate licensees. That's what we leave for the attorneys, right?
Right. And be grateful for that. I'm like, I don't want to draft. I always, when I'm teaching deeds of trust, I say, let those law school people do it. That's their area. There's a lot of liability that goes along with what they do. And I'm like, let's leave that to them and let's focus on what we do. And also be careful with questions. To this day, it shocks me that people will miss this. They'll say, is it okay if Jason is my buyer client we make an offer on a property and we get a counter offer, and Jason's out on his sailboat and he says, hey, I'm on the sailboat, Rob, you're my agent, can you just initial and sign that counter offer? Well, no, I cannot sign on your behalf. I cannot initial on your behalf. I can certainly help you negotiate. I can help expedite getting it to you. Thankfully, we now have electronic signing options are abundant, and so I don't need to rent a motorboat and go out there and bring the paper contract to Jason. I can shoot it to him via DocuSign or .loop or zip forms or whatever. And so also remember, we can't sign or initial on behalf of our clients.
Yeah. A couple of other important points I think to add here is we don't see this happening in the real world very often in terms of drafting the actual contract. Like you said, certainly we don't draft deeds or deeds of trust and things like that. Where we typically see licensees being tempted to draft something is more so like an addendum, right? Something that is added to either an offer or an amendment. They might be tempted to draft an amendment to the contract rather than using what's available by an attorney or the Realtors Association. So they might be tempted again, like email an addendum that they wrote, or the email itself is the addendum.
Right.
By the way, this the riding lawnmower and the lawn furniture are to convey with the purchase of this home. No, again, and you cannot draft that. And to kind of add a little bit of conflict here, what's interesting is we're specifically talking to licensees. Your clients actually may draft something. I certainly would not recommend that they do that, but if they don't hold a license, a real estate license, then we can't say what they can and can't do necessarily when it comes to drafting their own versions of contracts or things like that. They can do that. And of course, if they did that, we would be responsible for presenting an offer, for example, that was drafted by a client, but we as licensees cannot be the ones drafting that. So it's always best to use what's already available. And if not, contact your attorney for something specific.
Yeah, that's a great point. And I always think of it as, because I've been to court a lot in my career, unfortunately, usually never as a defendant, always as a plaintiff, and doing property management. And I look at it from a standpoint of, what do you want to be standing in front of a judge and say, Your Honor, here is the agreement, right? And so if I write something up on a cocktail napkin or even a sheet of paper, I typed it. Well, I'm not an attorney. And one thing I learned, the best legal advice I ever got early in my career was, don't pretend you're an attorney. Judges hate that. Magistrates hate that. And so don't go in there trying to say, well, Your Honor, I wrote this contract. They both signed it. Should be good. Because the judge is going to tell you, no, you're an attorney. You're not, unless you're an attorney, you can't draft these legal documents. However, as Jason points out, the do-it-yourself, what I call the DIY landlords, or the DIY for sale by owner, happens frequently that people can draft their own lease or their own sales contract. The difference is they own the property, right? Jason's looking to lease out an investment property and he owns it personally. He could sit down and write that lease because it's his property. But if Jason is acting as a broker, and remember, I always tell people a broker is the matchmaker, the love doctor. If he is brokering a transaction between buyer and seller, or between landlord and tenant, he does not have the authority to create a binding document that binds them to this particular transaction. So could you do it for your own property? Yes. Could you do it as a broker for other people? No, you may not. They need to consult an attorney. And by the way, when it comes down to you're before a judge, that's where we say, look, even if they want to write their own contract or their own lease legally, yes, they can, but I don't necessarily recommend that. I would recommend that they use an attorney, and you can buy contracts or leases. If you're not a realtor, a lot of closing attorneys will be glad to sell you one that they have, like a stock contract, a stock lease. They could buy that from that attorney, and that's, in my opinion, far more likely to be upheld in court than something I sat down and wrote myself, because for good reason. That person who drafted it went to law school and has the authority to do so, as opposed to somebody that just woke up one morning and decided to write a contract.
Yeah, exactly. And as you mentioned earlier, I'm grateful that we are not allowed to do this because I
Yeah.
don't want to be responsible for drafting legal language. One other point here, and this is just how important this particular topic is. But you mentioned there, Rob, that we may only fill in the blanks. But what about if we use a pre-printed document, a legal document that's provided to us from either an attorney or the Realtors Association. And we don't like something that it says in there, or my client actually is the one that doesn't like something that it says. Can I just cross that out and make some adjustments to it?
Careful with that one, because I would say if any explicit terms, anything that we're crossing out and changing, I would have the attorney write it in themselves, or not the attorney, excuse me. I think it's going to be better if the client writes it in themselves, if at all, right? I would be very careful with that. And I would always recommend someone consult an attorney before they start modifying the contract. But I'm personal feeling on it is that it would be far better for the client to do it themselves. And so I always worry about later on down the line, if I do stuff like that, if I write in explicit terms or I change something explicitly, does it get into a he said, she said, he said, and they say, well, I never said that. Mr. Broker took the authority to do that on his own. And I would feel far better with the client themselves modifying the contract or consulting an attorney to perhaps create an addendum that I feel the addendum, if both parties agree to it, it should be pretty ironclad at that point.
Awesome. Okay. All right. That makes a lot of sense. So no drafting. Got it.
No drafting. Leave it to the NASCAR drivers.
Yeah. Let's
Right?
talk a little bit about advertising now. Some do's
Yeah,
and don'ts of advertising.
pretty important, right? Because everybody's going to advertise in their real estate career at some point, right? Even if it's just word of mouth advertising. So let's break down the big three here. Licensees may not advertise or display. This is a very frequent test question. Let's say that Jason later this afternoon, he's going to be meeting with one of his buddies up there in Carteret County. And Jason's about to list his property for sale on the Intercoastal Waterway. Congratulations, Jason. And it's got a boat dock. It's got a boat lift. It's wonderful. But his future client is not able to sign the agreement today. Maybe he's out on his sailboat. And Jason's future client says, hey, thanks for the information, Jason. Everything sounds good. I can't sign the agreement today because I'm out on the water. Why don't you go ahead, put your for sale sign in my yard? Let's go ahead and get this thing up and running on the internet. And I will sign that listing agreement tomorrow or Sunday or Monday, whatever. I'll circle back and sign that agreement later. Don't do that, right? You cannot legally advertise or display anything about a property for sale or for rent until you have a signed agreement with that property owner, whether it's a listing agreement or a management agreement. And in such, you need on those agreements, it literally breaks down how they will allow the property to be advertised, because they may not agree to a real estate sign. They might have a crazy neighbor that they don't want to see the real estate sign. It may be a husband-wife situation where they don't want to see the real estate sign. They may be relocating for work and not told their employer yet. Whatever the case may be, they may be a celebrity, a notorious celebrity who doesn't want their property advertised on the internet, et cetera. So always remember, number one rule, you cannot advertise your property till you have a signed agreement with that property owner. And also you're going to need their specific consent to do things like a for sale sign, like MLS, internet advertising, and even they still have this on the agreement, advertising other than the internet. I'm not sure. I mean, I could see that being, postcards, flyers, that type of thing. There's not too many people advertising in the newspaper or magazines anymore, but that still exists. So all that will be broken down on the agency agreement.
Yes. And then you say here, the provisional brokers may not advertise any brokerage services without consent of the BIC.
That's
Wow.
right. Yeah. The BIC is responsible for all advertising done by pretty much all the agents in their office. But it's twice as important for the provisional brokers, because as a provisional broker, essentially all brokerage services you do are in the name of your firm and the name of your broker in charge. So really, you want your broker in charge to give you a thumbs up on any advertising you do. And I always remind people that includes social media, right? If you're posting something on social media about a new listing you're hoping to well, you shouldn't post it if you're hoping to get it, but a new listing you just received, or let's say you're advertising an open house that another agent has in the office, whatever, you need to, or just advertising yourself. Hey, I'm recently licensed and would love to help you. Here's an update on the, market. Here's an update on the interest rates. Here's an update on whatever. Great things. It's all about getting yourself out there in front of people. Just make sure that you, of course, have the approval of your broker in charge before you do that as a provisional broker.
Yeah, the bigs are watching. That's become a lot more. This particular rule has become a lot more difficult, of course, with the popularity of social media advertising and so forth. But at minimum, the bigs should be watching the advertisements, the social media posts, et cetera, of their licensees, especially those provisional brokers. They are responsible, and why they're watching is to ensure that you're not violating any specific licensing law, such as this next point here about blind ads. Tell us a little bit about blind ads, Rob.
Sure. Yeah, blind ads have always been very important part of the license law, commission rules, and a very highly testable subject. And so a blind ad would be advertising a property that belongs to someone else and not disclosing who you are entirely, right? Like you might disclose, hey, I'm Rob Grantmeyer. But if I'm Rob Grantmeyer, my name enough is not sufficient, especially if I'm affiliated with the firm, because as we always point back to, the listing agreements, the buyer agency agreements, they're not usually with an individual broker. They're most often with a firm. It's the firm's name. Let's say, for example, it's Better Homes and Garden Paracle Realty. That is who the agency agreement, the listing agreement, is with. It's not with Rob Grantmeyer. I'm signing it on behalf of the firm, but the firm is the entity who has been hired by the client. So I always say, listen, you want the firm's name in that advertising. You need, in order to be legally compliant, you need the firm's name in that advertising, even if you left your own name off, right? If you left your own name off, I don't recommend it, but if you left your own name off, as long as you have the firm's name, that's considered an acceptable ad. If I work for Better Homes and Garden Paracle Realty and I advertise a property for sale and I say, hey, it's a beautiful 3-bedroom, 2.5 bath, intercoastal waterway property, give Rob a call, 910-471 ... And I just violated license law by putting an ad out there that is considered a blind ad. We want to know who the firm is for really 2 reasons, because not only that's the person or that's the entity that was truly hired, but it's also, if something goes south, and sometimes things do go south in these real estate transactions, the firm is also legally liable, has legal liability. And if it ends up a situation where a buyer or seller feels that they need to perhaps, seek legal help, legal assistance, then knowing who the firm was is critical in that scenario. So it's who the agreement is signed with. It's to, like most things the real estate commission says, it's to protect the public, and the public has the right to know which firm I'm affiliated with if I'm advertising real estate for sale.
Yeah.
Or for rent.
Right. And that's a great reminder again of the purpose of the NCREC, as their mission is to protect the consumers. And we never want to inadvertently or flat out mislead the general public. And we sometimes do that when we fail to remember that The client, the listing or what have you, is a client or a listing of the firm, and you are a representative of that firm, and you're going to advertise on behalf of the firm. And we all actually see more violations here, Rob, in real world than any other advertising issue. I'd say number two might be crossing some fair housing lines in their advertising. Again, most of the time inadvertently, they didn't mean to necessarily, or they didn't understand the perspective that could be achieved with their mentioning of walking distance to the beach. Well, what if I don't walk? Or can't walk, I should say. So yeah, these are some of those violations that we see quite often, particularly again, blind ads. You have to include your firm's name and your firm's logo, perhaps, and again, make it obvious who it is that you work for.
And when I first started out in this business, and we still do this, we had what was called sign callers. And you actually, back in the day, you loved a sign caller. Sure. Because if your firm allows you to work as a dual agent, and even if they don't, if your firm does not allow dual agency, well, if they don't allow you to work as a dual agent, but let's say they practice designated dual agency, it's still nice when that potential buyer contacts you, because maybe I can't work for the seller and the buyer, but let's say I can work for the seller. Someone else from our firm can represent the buyer, and it's a good situation. We can advocate for either side. I can advocate for the seller, and someone else can advocate for the buyer. So the thing is, look, there's no problem with wanting to get the phone call, wanting the phone call to come to you. You'll notice on what we call the rider on a lot of these real estate signs, at least that's what we used to call them, has the agent's cell phone, right? Doesn't have the office number. And if you work for a firm that allows you to practice what I call true dual agency, where you work for the seller and the buyer, that's a little tricky, but it is legally possible. You want them to call you, right? You want them to call you. Who better to help sell this property than me? I know the property as well as anybody. So it's no problem to have your name there. It's no problem to have your phone number, but you have to include the firm name as well. We need the firm name. Now, I'm going to give you one minor exception that people sometimes forget about, and that is if you are what's called a broker sole proprietor. If you are on your own, you're not affiliated with a firm, well, then there's no firm to put, but we still need you to mention in your advertising that you are in fact a broker. You can't make the ad read that you're just some guy or some gal or whatever. If you are not affiliated with a firm, you need to at least at a minimum put broker sole proprietor, so they know they're dealing with a licensed real estate professional and not just a common citizen who's selling a house, that type of thing.
Right. Yeah. I believe you have an example coming up next. Let's
look at it. So take a moment, friends out there in Zoom land, and let's see which of the following is an example of a blind ad. So take a moment, read carefully, and pick your blind ad there. I'm going to say it's A. It's nice when you could stop at the beginning, but remember, always read all the questions, because sometimes you fall in love with the first pretty answer and then you later regret it. So beautiful 3-bedroom home in Surf City. That's a wonderful town right up the road from me. Called Joe at 910 ... Well, the problem is, and now listen, A would be okay if Joe is a for sale by owner and not a broker. But even if Joe is selling his own house and he's a broker, he would have to disclose that seller or landlord or whatever is a licensed North Carolina real estate broker. It's our way of saying, hey, listen, you're dealing with a real estate broker, right? You're not just dealing with mom and pop Joe, right, who's selling his first house ever by himself. If Joe's a real estate broker and this is how he lists the property, that's illegal. That is a blind ad. So B and C must be okay. B says beautiful 3-bedroom home in Surf City, called Joe, broker sole proprietor. That's fine, because he's identified that he's a broker and that he's not affiliated with a firm, and he's given you his number. And then C, even though we don't see Joe's name listed, Joe's not going to like this, but it is legally compliant if Joe is affiliated with Paracle Realty, because most importantly, above all else, If you forget about sole proprietor, what's that mean? What's that not mean? If nothing else, remember that if you are affiliated with a firm, then that firm name needs to appear in your advertising, right? Needs to be on your business card, needs to be on your social media post. If you are affiliated with, if you're posting social media about what you had for lunch, that's okay. You don't need to name the firm. But if you're posting social media that about real estate brokerage related activities, then give us the firm name, because that's who you represent. And be proud of that great Paracle Realty name. And not everybody gets to work for Paracle Realty. Consider yourself, you're the special forces of real estate, and wear it like a badge of honor.
That's right. All right. I think we've gotten that point across. And also, just to reiterate too, on your last slide, those PT arrows, for those who are perhaps just joining us, we like to remind folks those red PT arrows are, again, problem topics, which come from the Real Estate Commission. And essentially, these are areas where we have seen patterns of students answering these types of questions wrong most often. And so, again, just kind of stand out, not to discount anything else, but these are, again, areas where students are notoriously, for some reason, answering these wrong. All right.
And I can understand it, because they can dress this up to say, for example, a seller and I have 100% agreed that I'm going to list their property for sale, but we don't have it in writing yet. Well, that would be fine. The seller gave me their permission to go ahead and advertise it. It's not okay. Yeah. It's not okay, because I cannot legally advertise the property till I have it in writing. So that's the way they could write that question. I could see where people would fall for, well, it's their property and they gave me permission. Well, the type of permission you need is in writing, because I've learned over 46 years that people don't always remember the same conversation exactly the same. And so that's why, if you have a written agreement, we can all feel good and sleep well tonight about the fact that you're now advertising that property. But you may have gleaned from a conversation that you have their permission to do it. Meanwhile, they may be interviewing other firms, and you're practicing illegal brokerage by advertising a property that you don't have a contract with.
Oh, the term parole evidence rule comes to mind in that point that you just made. So if you don't know what we're talking about there, make sure you look that up. Parole evidence rule is a question on your exam, most likely. Let's give our audience another important number to remember. Throughout the series, we've talked a few things. We've mentioned a few dates, important dates, and then a few important numbers. Here's another number, and that is 3. The significance of 3 when it comes to what, Rob?
A lot of things. 3 years, for example, is how long we have to retain our transaction records for successful or even unsuccessful transactions. 3 business days comes into play in the financing world when we talk about TRID regulations. But here's another example of 3 days: delivery of instruments. And you could also bridge this with must present offers within the same time frame. So let's talk about just giving people their contract, right? I'll tell you a great story on this. When I was a property manager, I occasionally would have my client I worked for had houses all over the place. And occasionally I'd, let's say, rent a house 2 counties away. I'd show up, we'd sign the lease, everybody's happy, fist bump. And I'm like, great, as soon as I get back to the office, I'll email you a copy of this lease. And the person says, oh, I don't do email. And I'm like, okay, I'll mail you a copy. And then, so I got to get there. Well, I can obviously mail it to the house, but I got to go get stamps, and I got to go get envelopes, because I don't mail very much if I can avoid it. So anyway, I learned from that, and I said, here's what I'm going to do. I'm going to bring 2 copies of the lease, have my now tenant sign both. Here's your copy, here's my copy. And in doing so, I always stay compliant with the 3-day rule, because the rule says I must give a tenant a copy of that lease within 3 days of execution. And execution means signed by all parties. I must give a seller or buyer client or landlord client a copy of their agency agreement within 3 days of execution. I also must give the buyer or seller client a copy of their offer to purchase within 3 days of execution. And in this case, it's going to be 3 calendar days. There's nothing specific. Always, I say just go by calendar days, 365, unless they say otherwise. And so this is 3 calendar days. So if Jason is signing a lease today, day 1 would be tomorrow, day 2 Saturday, or no, tomorrow is Saturday. What am I? I'm trying to push us further away from the weekend. Day 1 would be tomorrow, day 2 would be Sunday, day 3 would be Monday. By Monday, I must make sure he has a copy of this. And I love this law because nothing aggravates me more than I'm in an agreement with an insurance company or a mortgage company or a broker, whatever. And I don't have a copy of my stuff. I don't have a copy of the contract, the paperwork. And so I feel like this is a really, really good rule. You want to give it to them immediately. Don't feel like you have to wait immediately, but no later than 3 days from the date of execution.
Yeah, and with the many options of the digital signatures platforms that you mentioned earlier, that makes this law a lot easier, because technically or typically I should say, with these types of digital signature platforms like Zip Forms or DigiSign or what have you, they will provide a copy after it's signed right away. The system, that is. So that makes it really easy, but definitely another 3 to remember here, right? 3 days to deliver any and all copies of executed documents. Very good.
Right. If in doubt, pick the number 3. About the only time it doesn't work out is occasionally you'll run into the number 2. For example, you need 2 years full-time experience to be a broker in charge, but just about everything else is either 3 days or 3 years. So if, as Jason would say, he's always says, guess C on your multiple choice questions. I say guess 3 days. 3 days is a solid guess, or 3 years when it comes to how long you must maintain records.
Yeah, absolutely. All right, so wow, the content on the screen right now, Rob, you've got a big red star. You've got the PT red arrow, and you've got a change in font color to blue, and you've even referenced the rule number. So all of these things combined pretty much leads me to think, wow, okay, this is going to be some really important stuff, right? You've got the word underline. I mean, you couldn't be more emphasized here. So tell us what we're trying to get across here.
Sure. It's what I call the blowtorch blue right here. And it is a very testable and frankly, a very controversial topic in real estate. You may hear the term used called shopping offers. And in fact, it's legal in some states. In some states, you are legally allowed to, according to what I've heard. I've not visited the states and tested it, but I've had brokers in class from other states who said, oh, we're allowed to shop offers in, say, Arizona, for example. We cannot do that in North Carolina. And it's very important to understand what shopping an offer is and what it's not, right? And so let's say, for example, I work for a seller. They've got a house for sale here in Hampstead, North Carolina. There's a lot of demand for Hampstead, North Carolina, like there is with most towns in this state. And so let's say we get an offer this morning for $345,000. We get an offer this afternoon for $355,000, and yet another offer this evening for $356,000. And the seller says, hey, Rob, here's what you do, pal. Let me tell you how to do your job, Rob, because I'm sure they're an expert on that. They say, reach out. We got a $345,000 offer, a $355,000, and a $356,000. And the seller says, here's what you do, Rob. Reach out to all 3 and say, this is the top number. This is the number to beat. All right. So just so we're all on the same page, I want everyone on the same page. This is the seller talking, not the agent. Seller says, I want everyone to know what the number to beat is. And here's what I'm going to say. I'm going to say, Mr. Seller, I'm afraid that's not legally possible. I cannot disclose the price or material terms contained in a party's offer to purchase, sell, lease, rent, or to option real property, unless there is one exception, unless I have the express authority of the offering party. So the person who made, let's say, the $356,000 offer that came in this evening, if they want to give me permission to disclose their number, fine, I can do it. Now, what's the likelihood, Jason, you think they're going to give me permission to basically show everyone else their cards? What do you
That's
think
what's
the likelihood?
always that's what's always fascinated me about this particular rule here. I love how they give us that opportunity, but rarely will we ever get that opportunity from the offering party. Sure, go ahead and tell my competing offerors, what my offer is, and maybe they'll beat it. Again, that doesn't happen, but it's still in the rule. So, and this is another one of those kind of like the blind ads I was mentioning. This is another one of those that we sometimes see impulse reactions from licensees who, just kind of blurt out, oh yeah, if you could come up to X amount of number or something like that based on previous offers, it can get us in trouble. So again, we cannot disclose the particular price or material terms. Can we disclose though, Rob, that there isn't the existence of other offers or competing offers?
Great question. And the answer is yes. It is the fact that there are multiple offers is not a material fact, meaning it's not a mandatory disclosure, but as long as you have the seller's permission to disclose the existence of multiple offers, and most importantly, there are multiple offers, right? Some people are like, can't we just say there are? No. If there are, in fact, multiple offers, so in that same scenario I painted a second ago, is it okay for me to reach back out to all three of those offerors, those potential buyers, and say, hey, just so you all know, this is a multiple offer situation. Please make sure you are bringing your highest and best offer forward. And then if they want to make a higher or better offer, they can. But that's literally the limit. That's the most I can say, is that we do in fact have multiple offers. And I hear this broken so many times. If I had I'd be retired right now if I had $1 probably for every time I heard someone say, we have a full price cash offer. I'm like, you're not supposed to tell me that, right? You're not supposed to tell me
That
that.
impulse I was telling you about.
Yeah,
Sometimes
it's
it's
the
like,
impulse. And hey, I mean, in a way, in a kind of embarrassingly unethical way, I'd say, well, thanks for the heads up. So I know we're going to have to come in quite above that full price, but they've broken the law. The law does not, and because it's not fair. That's what I always go back to. I'm thinking, hey, well, you helped me out, but there's a great line in a video I use in post licensing that says, beating the other guy that way is not fair, right? We should not be beating the other guy because you've told me what the number to beat is. And I like to say the way real estate works in North Carolina is a lot like a silent auction. You don't know what the other people are offering. And the most I'm allowed to tell you about their offers is that they exist, if they do in fact exist, and you should bring your highest and best offer. If you really want this property, make sure that you bring your highest and best offer. And that's the most I can say. I should not tell you that it's full price. I should not tell you that it's a cash offer or a conventional loan, or that they put a $50,000 due diligence fee down. All of that is illegal unless we have the permission of the person who extended the offer in question.
which again doesn't happen.
Doesn't happen. There's certainly no benefit in it. If they're just at that point, I don't care, I've moved on. Well, in that case, then they need to go ahead and withdraw their offer anyway. And so I can't really think of any scenario where it would be in a potential buyer's best interest to let someone know what their offer was. It just doesn't seem to make sense to me.
Right. And it's important too that this rule applies even after you are under contract and you have changed the listing's status in MLS, for example, to pending, right? And you're just waiting for the transaction now to see its way through to closing. Again, we must not disclose any material terms or specific contract price on that listing until it has closed.
Mhm.
right? So again, that's something that we might see too. Um, someone might be calling up a listing agent to say, hey, I know you're pending and everything, but I'm getting ready to list one, next door. I'm wondering what you're under contract for. Can't
Sure.
close that, right?
Right. And there's also the potential for backup offers. Someone might find out what the terms are so they can make a backup offer. Now, a backup offer, even if it's accepted, doesn't mean the seller can kick the first buyer to the curb, but it could change the seller's perspective in terms of how they negotiate due diligence, repairs, stuff like that. So I really appreciate this rule. I think of it as it's sacred, that whatever, and even if they're not my client, this applies to clients and customers alike. Whatever someone offered for a property, it's a silent auction. I don't have the right to turn around and share that with other people.
Yeah, I like that term, silent auction, or that metaphor, so to speak. That's pretty good. I'll have to start using that. But you're right. That's exactly what we have here in North Carolina.
Yep.
And sometimes that actually works out best for the seller. If you just say to someone, bring your highest and best, rather than we've got an offer for 356 and they come back with an offer of 357. Well, the person that's coming back with their highest and best might have come back with 386, versus
Sure.
just $1,000 above. So it does work out for the seller as well.
As a mentor of mine once said, there comes a point in every conversation where the person who talks next loses. And so sometimes you want to be the
Oh,
person
that's
that
good.
doesn't talk next. You're like, bring your highest and best. And maybe they offered you 15,000 more than you expected. And you go, okay, that'll work. And, or, it's
Right.
sometimes the less you say, the better.
Right. Exactly. I remember that. I'll remember that for sure. All right. Here we go again with a number three. I believe
How
you
about
mentioned this.
that? 3 years.
Yeah, 3 years again.
3 days, 3 years. And so retain your records, right? Retain your records. I get a lot of questions on, well, how do you do it? I'm like, well, in my day, we had file cabinets, and some companies still do, and there's nothing wrong with that. But you can also have a Google Drive or a Dropbox Drive. But you're required to make your records available for real estate commission auditors for 3 years from successful or unsuccessful transactions. And I always like to point out it's from the conclusion of the transaction, right? The 3 years begins at the end of the transaction, not from when you first meet the person, but from when it closes. And if heaven forbid there's a lawsuit and the lawsuit goes past the closing date, then the 3 years begins at the end of that lawsuit. So from the last day that you're involved in this transaction, you must retain those records for 3 years and be able to make them available electronically or physical copies to the real estate commission.
Yeah, absolutely. All right. Let's combine a rule that has disclosure components and compensation components here.
Right. This used to be a big deal in my world when it comes to property management. This is something you'll face a lot in property management. Once upon a time, I had a really good housekeeping company that cleaned a lot of short-term rentals for me. And they said, hey, we appreciate it. And they were really good. It's to me, I say that's one of the hardest jobs in the world,
Yeah.
is doing turnaround cleans in the summer or in the winter or whatever, winter in the ski resort, summer at the beach. Really hard work, and having good people, especially in a rural, remote area like this, is critical. Anyway, I found a good company. I tried to give them as much business as possible, and they said, we appreciate it. What can we do for you? I said, well, what do you mean? She said, how about we start cleaning your house once a month for free? And I said, let me think about it. No, I don't want you to do it. I said, legally, you could clean my house if I have the permission, all right, the written consent of my clients. And I said, to me, that just doesn't, I don't like the taste of that. I'm like, I feel like they'll wonder, is this really the best company to use, or is Rob assigning this company to our house because of the benefit to him? So I said, you know what, friends, cleaning company friends, just please continue to do the great work that you do and give my clients the best deal, the best price. And that will create a win for me because my clients will be happy. Our customers who are the renters will be happy. And I'll not lose properties and I'll gain more properties. I'd much rather have that than a free house cleaning once a month or twice a month or whatever. So remember that you are allowed to accept that valuable consideration if, and I mean, first, you have the obtained written consent of your client. So if you have the permission of your client to get paid that kickback from the cleaning company or from another similar company, then that's fine as long as you have the permission of your client. So to me, I always felt like it just didn't leave a good taste. And so I didn't do it. But there are plenty of people who do it. And as long as you have the client's permission in writing, then you can do it.
I'm curious, Rob, did you tell your wife that you declined that offer?
I did. She didn't love that. She didn't love that. But I always point out the same guy who told me the story about who talks first would point out the health benefits of cleaning your own house, right? It's good exercise and it's good for the soul. So that's how we came about it. So, and I still keep in touch with that housekeeping company. She's still a good friend to this day. She's starting a summer camp for kids this summer. And so total dynamic entrepreneur with a lot of different businesses. Pretty cool stuff.
Fantastic. One of the common examples that we see a lot regarding this, and luckily it's in the pre-printed listing agreement that we typically use from the Realtors Association, and that is any fee or commission that we earn as a firm for recommending or arranging a home warranty service, for example.
Great example, yeah.
So they've already included that written consent there, by signing the listing agreement with the firm, that they understand that if we arrange that home warranty, that the home warranty company is providing that additional fee to the firm. So another example there.
Yep,
well, let's take this issue of disclosure and compensation one step further. What about brokerage services?
Absolutely. And so third party, right? And really, let's leave the third party out of it for just a sec, because I think we'll get there in a moment. Let's just talk about getting paid for any brokerage services. And the deal is, it's got to be in writing, and it's got to be in writing on the agency agreement. And so I can't just accept, I'll give you a $5,000 check if you help me do this, right? It needs to be in the written agency contract, not the offer to purchase. That question shows up a lot. Remember, agency agreement is between client and firm, and the offer to purchase contract is between the buyer and seller. I always tell people, as the broker, leave your compensation out of the sales contract. I heard an example one time that always stuck with me. A lady who moved to Chatham County from San Bernardino, California. When she sold her house in California, she literally got an offer to purchase that said it was contingent, and I'm pretty sure I know who wrote this in. It was contingent. The offer was contingent on the buyer's agent receiving a 4% commission instead of a 3% commission. And she said, "Is that legal?" I said, "Not in North Carolina, probably not in California either, but you cannot put anything about your compensation on the offer between buyer and seller. Our compensation must be in writing, and it must either be on the listing agreement or the buyer agency agreement. Sometimes it's on both, depending on which side you work for. If you're a buyer agent, it could be agreed on the listing agreement that they're going to cooperate and pay you such and such amount of commission. And then it's also going to be on your buyer agency agreement that the buyer is agreeing that you're entitled to a certain amount of commission for the successful transaction once the transaction's completed there. So it always has to be in writing, and it always has to be on the agency agreement. Now, you might find out later that you're going to make more money, or you might agree to take less money than what you initially thought on the agency agreement, and that's fine. Hopefully it's more money. You can always revisit that agency agreement, that original buyer agency agreement, change it and have both parties initial and date it. You can't just change it unilaterally and say, hey, buyer, I've decided you're so much work, I'm gonna up my fee. Well, no, but you could certainly say, well, buyer, I found out that the seller is willing to pay more than we thought as far as commission. And so let's go back, revisit that buyer agency, let's modify it. And as we'll see in a sec, we also want to make sure that on the agency agreement, we always make sure that we document any third-party compensation as well.
Yeah, great reminder here that, the sales contract, sometimes we refer to that as the offer to purchase and contract, again, has nothing to do with the real estate agent, including his or her name and or his or her compensation. So if you're, again, with a test question that says something to the effect of, and the answer choices, a sales contract includes all of the following except. If you see the word except, number one, circle that or write that down or what have you, to make sure you understand you're looking for the exception.
Right.
But then also you will see something like compensation or commission, I should say, is on the sales contract. No, that is the except there, nothing to do. And if you think about it, we don't even sign it. The agents don't even sign the offer to purchase and contract. More or less discuss compensation on that. That is the wrong place for that. And as you pointed out, Rob, the right place is the agency agreements,
right,
for anything related to compensation.
And they take that very seriously for that very reason, because as you can imagine, the temptation has been there, especially if you have a highly motivated seller who is desperate to unload their property, to say, all right, well, my buyer will buy your property, seller, but I want you to pay me more money. And you can't do that, right? The offer to purchase is between the buyer and seller. And so my compensation as the broker needs to stay away from that particular contract.
Right. Let's take it a step further.
Let's take it a step further. And we're going to talk about nominal compensation in a little bit. Don't want to leave that off totally, but I'm going to circle back to it. So what about builder's incentive, right? This is an example of third-party compensation, right? And this, I don't know if this is quite as common in 2022 as it was a couple of years ago, but if it's a little bit slack at the moment, trust me, it'll be back. It'll be back. And under most market conditions, residential market conditions, builders, new homes builders are often willing to pay a commission to a buyer's agent, almost always willing to pay a commission, and maybe, depending on the circumstances, an incentive above and beyond, right? So let's say a builder's willing to pay me a 2.5% commission plus an incentive. Maybe that incentive is a $3,000 bonus. Maybe it's a vacation trip to the Super Bowl. Maybe it's a trip to Cabo, whatever, right? And so can I legally accept that incentive? And by the way, if you're wondering, well, why would they do that? Well, my experience has been, the last quarter of the calendar year and the first quarter of the calendar year, when the real estate market tends to be the home buying market tends to slow down a little bit. That's oftentimes when the builders are willing to offer some extra incentives. Not that many residential properties sell in November, December, January, February. So builders might say, hey, we'll make it worth your while if you bring us a well-qualified buyer. And can I accept their trip to Cabo or their trip to Miami or whatever? Sure, as long as I have my client's permission, right? And the best place to do that would be on the buyer agency agreement. But not only that, it's not enough just to, at some point before the buyer closes, to make sure that I mention that hey, buyer, by the way, I'm getting this free trip to Cabo. I'd love to take you with me, but I only get one ticket. So just sign here that I'm going to Cabo. Can't do that. I need to disclose in a full and timely manner. And what I've always emphasized, full and timely means full amount. Don't say it's some type of bonus. I don't know what it is. Tell them what it is, right? It's a trip to Cabo. It's $3,000. It's a trip to what is it? And timely, I always say disclose it as soon as you find out about it. As soon as you find out about it, ideally before you even show the property.
Right.
It should always be disclosed before you show the property, with possibly the only exception being I truly did not know about it. They didn't tell me about it until later. But if you know about it, you darn well need to make sure your buyer knows about it, because frankly, people have filed complaints. This is a very common complaint with the real estate commission. Just about every bulletin that comes out, you'll see a broker reprimanded for failing to disclose some type of third-party compensation, and the buyer feels cheated. They say, well, listen, I didn't really want that new home. I really wanted that resale, but Mr. Broker was twisting my arm saying, no, you really need to buy this. And come to find out, Mr. Broker got a trip to Cabo or a trip to Disney World, and I didn't find out about that until later, and I feel cheated. And so, of course, they're going to complain to the real estate commission and probably have a good case. So disclose it, what it is, in a timely manner, always before you show the property, unless of course you don't know about it.
Yeah, again, this rule is in place in part so that we are reminded that we have to do things that are in the best interest of our client, not in the best interest of us. And although it is in my best interest to go to Cabo, let me tell you, I cannot mislead my buyer client, for example, into, or push them into buying this house because I get this, incentive, especially if I'm not disclosing that incentive. That, again, as you mentioned, is a huge case for an issue or a compliance issue with NC-REC. So you never want to mislead your client or the public like that. So disclosure, full and timely manner, hugely important there.
I take that issue personally because there's not too many things that really set me off. But if I find out someone is pushing me into doing something for their own personal gain instead of what's best for me, that always bothers me. I'm like, a little backroom deal. I really take that personally. I don't like it.
Yeah, so much for fiduciary duty, right?
Right, exactly. It's just dishonest. And so let's talk about what is nominal compensation. And I used to struggle with this. So the first time I looked at this, I said, well, if it's less than $50, it's nominal. Well, sort of, right? But let's say, for example, that my pal, the housekeeping company, my pal Carolyn, who owns her own housekeeping company, if she paid me a $20 kickback for each property she cleaned, that would not be nominal compensation, because nominal compensation needs to be a smaller amount. $25 amount or $20 amount's okay, but nominal means it's a one-time gift. It is not a per transaction basis. If she's paying me 20, there's people that think, well, just give me a $50 gift card or $49 gift card for each deal I send you. Well, that is not nominal. Nominal is a one-time gift. For example, if my pal Carolyn wants to bring us smoothies to the office one day because she appreciates us, wonderful. And this is, I always warn people, brace yourselves. If you're going to work in the real estate industry, you better make sure that you're working out and dieting throughout the summer and fall, because once the holidays kick off, it starts with Halloween with everyone's leftover trick-or-treat candy. Yeah. And then months of November and December, you're constantly getting gifts from mortgage companies and home inspectors and closing attorneys. And it's usually really good stuff, right? They're not getting the cheap stuff. They're getting like the gourmet cakes and cookies and really good stuff. And so can they drop off a tray of bagels? Sure. Can they visit our sales meeting or a happy hour? Paracle Realty, home of the office happy hour, and in addition to sales meetings. And so could they sponsor that? Yeah, but the key is it's a one-time gift, and it's not going to exceed $50 in value per agent. If they spend $300 sponsoring an office happy hour and there's 60 agents there, well, that's far less than $50 per agent. So remember, it's a one-time gift, less than $50 in value. If they're giving it to you on a per transaction basis, then it's fine as long as you have the written permission of your client.
And just to clarify, you're saying that these types of nominal gifts, nominal compensation, are not what we were just discussing in terms of has to be disclosed on the buyer's agency agreement, listing agency agreement, et cetera, right? These are not necessarily falling under that disclosure rule.
You got it. You don't have to disclose this. You can just enjoy the tray of muffins, the tray of muffins from Muffinville or whatever. Enjoy it, and that's fine as long as it's a one-time gift. There's no need to disclose it here.
Got it. All right. Let's throw a quiz question out there to our audience.
Let's do it. True or false? A North Carolina provisional broker may be paid a bonus directly from a new homes builder once they have the written permission to receive this bonus from their buyer client. Read it carefully. Think about it for a sec.
Sounds to me like you've got a couple of different issues in here.
A lot going on here. There's a lot going on here. And that's why I always I hate to say it like this, but we don't want you to get too comfortable, or as a wise man once said, get comfortable with being uncomfortable.
Yeah.
And so there's a couple different things going on here. The second half of this question makes you feel pretty good about it, right? Well, I've got the written permission from my client. Well, good. But if you're a provisional broker, you cannot be paid any compensation directly.
Everything. You know what, Rob? I didn't even see the provisional word there.
It'll do you like that. It'll get you like that. So a NCPB, I just got a question, ironically, from a former student this morning who's a practicing broker now about provisional brokers. And I said, look, everything's got to flow through the firm. In fact, that rule's the same now for your for all brokers who are affiliated with a firm. So everything flows through headquarters, as I like to say. So I'm going to say they can pay you. I hope they will, as long as you have permission of your client, but it cannot be paid directly to you. They may receive the bonus, but it must be paid through your broker in charge. Is your BIC going to take a cut? I don't know. That's between you and your BIC. But all transactional compensation for affiliated brokers must flow through the BIC, or flow it through headquarters, as I like to say. They cannot pay you directly because you're a provisional broker. And truly nowadays, if you're affiliated, all transaction-based compensation, including referral fees, is expected to be paid. So be careful with this. They might say, well, why don't you just make the check out to me directly, and Mr. Broker in charge doesn't need to know about it. Be careful, because you could find yourself in some hot water for that.
So essentially though, Rob, if you just took out the word directly in this question, that would change the answer, right?
It would. Absolutely. You're right. North Carolina provisional broker may be paid a bonus. I love the way you do that. You're like, that's what our pal Deborah Carpenter once said, is what could you change to, flip the answer around and make it true, or flip it around and make it false. Right. So could a PB be paid a bonus from a new homes builder once they have the written permission to receive the bonus from their client? Absolutely. Yeah. So if you take directly out, the problem is they can't pay it to you directly, and the temptation will probably be there to be like, just pay it to me directly.
And without the word directly, you still may have some students that argue with the question, and we tell you not to do that. And in this case, their argument might be, well, yeah, they can be paid, but it has to go through their BIC. Well, that's not what the question is asking you. Yeah. If we, again, took out the word directly, we're just simply asking for a true or false option here. So a good lesson here, again, not to argue with the question that's been presented. Folks will tend to read too much into it. So major or a great example of how one word can really change the outcome here. And so why we stress to students to read every word.
Yeah, and specifically, the great real estate philosopher Kim Stotesbury, once I heard her say, pay attention to the adjectives, right? The adjectives, the descriptive words like directly, like non-provisional, provisional, that type of thing, permanently attached, that type of thing. And so all that plays a role in whether or not the answer is right. So look for those descriptive words, because a lot of times the question can hinge on that one word. And shoot, half the time we see the word, but we don't truly observe the word, right? You got to make sure that you're seeing as well as observing every word in the question.
Exactly. That's kind of like what I'd say to some folks. They heard me say it, but they didn't listen to what I was saying.
Yeah, yeah.
It's a big difference there. All right, what
And
do we
we're
got?
all guilty of it.
Yeah.
We all eventually. That's why you're not required to get 100 or even a 90 on the test. You're going to miss a few.
Yeah.
You just need to get 75% right. So that's the key. You're not going to bat 1,000, but you want to win more than you lose when it comes to this test. That's for sure.
Yeah. All right, bud. What do we got next?
All right, let's talk about kind of similar along the same lines with the contract stuff. Is we said that as a broker, I can't put anything on a client's offer to purchase about my compensation. Well, the other thing I cannot do is remove myself or disclaim liability. I can't say, well, friends, I'm writing this offer on behalf of, or filling in the blanks of this offer on behalf of my client, but I'm going to take myself out of the equation after today. I have no further liability. In North Carolina, the way I look at it, you always have liability to a client. Sometimes you have liability to two clients, but you always have liability to at least one client. So you cannot put anything in a pre-printed sales contract disclaiming yourself from liability. So no way. And then also, as we just said, you must disclose additional compensation, but of course not on the pre-printed sales contract. So those are very commonly asked things with regards to the offer to purchase. I jokingly say it's my two favorite things: more money, less responsibility. And I can't have either, right? I can't have either on the offer to purchase. The offer to purchase is not about my money as the agent, and it's certainly not about less responsibility for me. I have full fiduciary duties to my client. And if I want more money, I can certainly ask for it, but that's going to be between me and my client, and it belongs on the agency agreement.
Yeah. Yeah, the only numbers that should be on the sales contract are purchase price and any deposits made and dates. Nothing to do with compensation whatsoever. Huge, important fact to remember there.
Perfect.
All right, let's touch again on those pre-printed sales contracts. Again, which ones may we use, may we not, et cetera.
Yes, absolutely. So I've had the luxury of working for several different real estate companies in my career. And I remember one of the first companies I worked for was a development company. And we had our own contracts. And by we had our own, I don't mean like I sat down and wrote them, but they paid for an attorney to draft the sales contracts. And those contracts were a little bit more there were a couple things. They were easier to understand. They were a little bit simpler than the traditional offer to purchase, because we mainly sold land for that with that community. So we had an attorney draft our own contracts, and that was fine. We want to emphasize that you don't have to use the North Carolina Association of Realtors 2T offer to purchase. It's a great option to use, but you can use pretty much any attorney drafted contract as long as it meets the criteria in Rule 58A 112, right? And you don't have to remember the rule number necessarily. I like to say it meets Real Estate Commission guidelines. There's exactly 20 things that fall under that criteria, but luckily, the Real Estate Commission does not expect pre-licensing or post-licensing students to know what all 20 of those criteria are, but they are things like, just so you know, things like obviously you need a sales price, obviously you need contract terms, obviously you need a legal description, you would need all parties named, that type of thing. And so that's the deal. You just can't, we're not going to limit you to only use the realtor firm. And not everybody works, very few people will find themselves working for a developer on a barrier island. If you're lucky, maybe you will, but there's a great chance that at some point in your career, you'll be involved in a transaction where there's a new home sale. And a lot of times new homes builders, if they do a lot of sales, will have their own contract drafted. So they don't necessarily use the realtor form. They will use their own attorney drafted contract. And that's fine as long as it meets those real estate commission guidelines and it has to be drafted by an attorney. And then just as a reminder at the bottom there, do not write in explicit contract terms at the direction of your buyer client or your seller client, because again, that can get you in trouble. We're not supposed to do it. And I know from experience that they may misremember, or I may misremember what was said. And so it's much better if they want it in that, they want to write in explicit terms, their best bet is to consult an attorney. Their second best bet would be to write it in themselves because it is technically their contract. But I want that in their handwriting, not my handwriting, so I don't later look like somebody who tried to perhaps take advantage of the situation or made a mistake.
Yeah, hands off there. Another important note about the pre-printed forms, we've talked a lot about or mentioned several times the Realtors Association provided forms and how we can certainly use those if there's a caveat here. If we are,
you got to be a member.
You got to be a member, right? So, again, part of membership benefits includes the access to the forms library provided by the North Carolina or National Association, but also North Carolina Association of Realtors, specifically when it comes to transactions in North Carolina.
And there are alternatives, because what I always like to point out to people, the 2T offer to purchase is the North Carolina Bar Association / North Carolina Association of Realtors. So you could potentially buy that contract directly from the Bar Association. It will not have the realtor logo on it, but that is one option you could go. But you can't, if you're not a realtor, just say, hey, Jason, I know you're a realtor. Would you mind printing me out an offer to purchase? Thanks, pal. I won't tell anybody, right? That would be unethical. That's a violation of the Realtor Code of Ethics. And Jason and I could both get in trouble for that. So exactly right. If you want to use the realtor forms for agency agreements, for offer to purchase, for leases, for management agreements, make yourself a realtor. You can join the club there.
Yeah. So again, you will see exam questions, especially here in the course, that essentially say something to the effect of what form must we use? And again, it doesn't have to be the Realtors Association form. Again, if you're not a realtor member, you can't use those forms, but it doesn't have to use those forms. You could use, as you say here, any pre-printed sales contract forms, as long as they are meeting guidelines from NCREC.
Got it, sir. All right. Also, since we're on the responsibility, let's talk closing statements for just a second. Earlier, I said I got a real pet peeve of when I don't have a copy of my paperwork, right? A copy, of course, I'm going to stick it in my sock drawer somewhere, but I'll dig it out eventually and be like, oh, this is my copy of my deed of trust, or this is my copy of my promissory note, or this is the copy I have of my homeowner's insurance declaration, whatever. And so I'm also, when I close on a piece of real estate, real property, I'm supposed to get a copy of my closing statement. Now, I'm not really getting it from the broker. I'm getting it from the attorney's office when I go to the closing, but my broker has a responsibility to do a couple of things to ensure that I receive a copy of it. And they can just simply verify, hey, Rob, just want to make sure that you got a copy of that final settlement statement. Oh, you did. Okay, good. The broker would also have a responsibility of verifying that the numbers on there are accurate to the best of their ability, which their broker knows or should reasonably know. They're not going to know every intricate detail of my financing if I'm a buyer, but they darn well should make sure that the due diligence fees are accurate, the earnest money is accurate. They should be able to double check the tax prorations, the HOA prorations, et cetera. And I've had students who I've taught what I call the swim to the closest wall method of prorating HOA dues and taxes, and they've caught mistakes. I had a client or a student not long ago was selling or his buyer was buying a condo at Wrightsville Beach and caught a $600 mistake, that he basically saved his buyer $600 because the attorney or the lender had not prorated the condo owners association dues. And so he was like, hey friends, we got a problem here. My buyer client is owed a credit of $600 for the association dues. And he immediately sent me a text, which we did like a make-believe high five. I was pretty excited about it. So, I mean, $600 could be thousands. So we have a very important responsibility to the best of our ability to make sure that our client, not both clients, right, unless you have two clients, but that our client, if I work for the buyer, I'm looking at the buyer's charges. If I work for the seller, I'm looking at the seller's charges. And I call it a proofread. You're supposed to proofread and make sure that those charges are accurate.
I tell you, in my practice, there has been more inaccurate settlement statements than accurate.
And that's a credit to you, because I bet you a lot of brokers would be like, I never noticed that, because they're not actually checking as closely as they should. And you being Jason Morris, you check very carefully.
That's right. Yeah, I mean, because again, it's the final accounting of all of the transactions, details and monies and credits and debits and things like that. So hugely important. Now we, build a foundation on this topic during pre-licensing, right? But then we really dive deeper into this in post-licensing courses. But another thing I think it's important to know is in terms of AKAs, as we call it, you're describing it here as the closing statement, but you may also see it or hear it referred to as the CD, closing disclosure or settlement statement. All of these terms used interchangeably, of course, but yeah, definitely.
And occasionally they'll sneak in a HUD statement.
Yeah.
And now a HUD statement could still potentially be used in like a cash sale. But yeah, you'll see it called lots of different things: settlement statement, closing disclosure core, HUD 1, whatever. Now the HUD 1 is different from the closing disclosure, but you could occasionally come across a question somewhere that maybe refers to it as slightly an outdated name or something like that. But basically it's the closing statement. It's the final itemization of what the buyer's paying, what the seller's paying. Usually the seller's walking away with proceeds, not always, but usually the seller's walking away with proceeds, and the buyer's usually paying cash at closing that will encompass their down payment plus whatever their closing costs are.
Right. Very good. All right. Well, let's shift gears and start moving into our final topic before we get into a quiz review. Let's talk a little bit about the North Carolina Timeshare Act and timeshares.
Yes. So timeshare, the glamorous side of real estate brokerage. And it's an interesting business, right? And we get pretty deep on it in post-licensing 303. For pre-licensing, for your PSI exam, I say just focus on the basics. You don't need to focus. I mean, you need to know the laws. When I say the basics, know the laws. Don't worry about the pluses, the minuses, the horror stories, right? The victory stories. So just focus on the laws. And let's start with, well, what is a timeshare? Well, a timeshare is essentially shared occupancy ownership. I like to emphasize ownership because you do own a piece of this property, but you don't own the whole thing. So you could potentially own 1 week a year at a specific property. You could own 3 weeks, 4 weeks, whatever, but it's not a rental, right? It's not a rental. It is a type of ownership, a hybrid ownership, shared occupancy ownership. And some people love it, some people maybe not so much, but let's focus on the laws regarding timeshares. Number one, you do need a real estate license, right? Because, this is in fact real property. So a real estate license is required to sell timeshares for others for compensation. But I like to point out, well, what about if I own the timeshare? Well, that's okay. You don't need a broker's license. But if you were selling timeshares that belong to other people for compensation, then you're going to need a North Carolina real estate broker's license.
What's
Step
taking us
one.
back to the beginning of our series here? Who needs a license? Who doesn't?
That's right.
Timeshare salespeople are no different.
Yep,
They fit that criteria. They fit that definition of who needs a license.
they do. So here's a few key terms, right? And we talked about, I'm sure you've seen timeshares before. This shows up in Unit 2. But here's some key terms kind of going deep here. They must be registered with the North Carolina Real Estate Commission, and they must be renewed each June. Just like my broker's license has to be renewed in June, the timeshare registration must be renewed each June. So we have that in common. And then they have what's called a registrar, right? That each timeshare community must have somebody serve as the registrar. A good question came up from one of my students one time. Does that person have to be licensed? And I said, well, it depends. Depends on what their role is. If all they're doing is registering the timeshares, then probably not. If they are meeting with buyers and signing contracts, then yes, they would need to be licensed. So it depends on their role. But a registrar, I like to say, it's like, go back to your college days where they had an office of the registrar where you showed up. If it was, pre everyone registering online, people like me showed up on registration day and were like, hey, I need to sign up for some classes. And so that was the office of the registrar, and they physically registered students for classes. Well, timeshares have an employee who is responsible for registering each new ownership, and they register it with the county in which the property is actually located. And then here's another interesting vocab term, project broker. So who in the world is that? Well, it's essentially just the broker in charge of the timeshare project. Project broker is the managing broker in charge of a particular timeshare community. And one of the few times you'll hear the word salesperson used for real estate brokerage in North Carolina. Timeshare salespersons, they are in fact brokers. They have a broker's license, but they're often referred to as salespersons. It's not a separate license. It's not that they go out and get a timeshare salesperson's license. They're just referred to as a salesperson within that industry. So project broker equals broker in charge. Salesperson equals the brokers who work under that broker in charge. Jason is blissfully quiet on timeshares because he's not had to work for a timeshare community. Hopefully you don't own a timeshare. I spent a couple months working for a timeshare developer, so I know a little bit about this exciting industry. So what defines it, right? We said that it is a piece of a property. It is a piece of the ownership. And so it's what I call the 5-5-5-10 rule. 5-5-5-10. Your ownership needs to be at least 5 stays at a property over at least 5 years with a 5-day rescission period. So I'll give you an example. And here's a timeshare I might consider. I like to vacation at Beach Mountain in the summer. That's my go-to happy place. It's nice. It's the highest elevated town east of the Rockies, so it stays nice and cool up there in the summer, relatively. Stays under 80 in the summer. Nights get down in the 50s, kind of nice. And so I go every year for the 4th. And let's say that the people who own the house I visit say, hey, how would you like to buy a timeshare in this house? And I say, what do you mean? They say, well, I'll sell you 5 weeks over the next 5 years. And I'm like, well, what's in it for me? Like, I could just rent your house. And they say, well, we'll give it to you at a discount. We'll basically give you 5 weeks over 5 years for the price of 4 weeks. Well, okay, I'd probably do that because I know I'm going to be going up to the mountains in the summer. And if it's at least 5 stays over, and now keep in mind, it's not a rental. I would be purchasing a ownership in this property. At least 5 stays, ownership stays over at least 5 years And then the last 5 is a rescission period. Just like condo ownership, if you buy a new condominium, you get 7 days. If you buy a new timeshare, you get a 5-day rescission period. Rescission period just means you can change your mind anytime in that 5-day period, and they will refund your full down payment. And then the 10 is that they must keep your any down payment you made in escrow for 10 days from the date of contract formation. So 5, 5, 5, 10, at least 5 visit ownership periods over at least 5 years, 5-day rescission period, and they must keep your money in escrow for 10 days.
All right. I think I got that. I didn't.
Yeah. And they must record your timeshare ownership, which we already know about. We said, hey, that's the office of the registrar. Now they must, this is a big one. They must provide, just like condos, they must, if you're buying a new condo or you're buying a new timeshare, the developer must provide a public offering statement, which breaks down a lot of important information. It should break down what the monthly or quarterly dues are. And that's where a lot of people get rubbed the wrong way on timeshares. They go, oh, it's not that expensive. But then you find out you got to pay $1,000 a quarter in maintenance fees or something to that extent. So they must, and the other question often comes up, can I rent my timeshare if I'm not going to use it? How does it work with selling the timeshare? Can I sell it myself? Do I have to sell it through the development company? All that information should be clarified on the public offering statement. Now get this, they must provide that offering statement to you, the buyer, prior to signing the contract. And trust me, from 2 months of selling timeshares, we didn't lead with the bad news. We weren't like immediately like, hey, Mr. Morris, just so you know, this thing's going to cost you $10,000 a year in maintenance fees. We didn't lead with that. We led with the emotional side. Hey, let's go take a look at the view from your potential new timeshare. What a view of the ocean. How about that view of the golf course and the ocean, that type of thing. So they don't have to share it with you prior to viewing the property. And same thing with condos. They have to share it with you, the offering statement, prior to signing the contract. And then a big one here is who can be fined. We know that the real estate commission cannot fine brokers directly. No can do. Never in their history have they fined, well, I wouldn't say never in their history, but currently they cannot fine real estate brokers directly. They can't fine firms directly. But you know who they can fine is a timeshare developer. They can fine timeshare developers $500 per violation of the North Carolina Timeshare Act with no maximum fine total. So for example, unlicensed person is selling timeshares for a developer. Each one they sell could be a $500 fine. Or if I am licensed, but I fail to provide the public offering statement to a buyer before they sign the contract, each buyer that we do that with, that's a $500 violation. And remember, it doesn't go to the timeshare employee or the timeshare salesperson / broker. It is a fine for the developer.
Well, and am I right? Sorry. Am I right? It's the allergy medications I'm on today. Am I right though, Rob, when I'm thinking that one of the most common violations that they make is back up to your point number 1 here, that they did not provide the offering statement prior to contract formation.
Absolutely. You got it. You got it. Because I'm here to tell you, it's oftentimes bad news. That's why after 2 months, I broke free from the timeshare industry, because I realized that there was a lot of hidden cost, and there usually is, right? There was a lot of hidden costs, and I got some good advice from yet another mentor who said, get out of there. Eventually this is going to come back, and some people were real happy with their purchases, but some people were not. And being a real estate broker, unless you're planning to move every few years, you want to build long-lasting, career-long relationships, and getting people to purchase something that they're going to regret is not a great way to build your business. So great example. Absolutely. Make sure, it's fine to help them fall in love with the property, but you got to give them the bad news, the offering statement, prior to them signing the contract.
All right. And just to reiterate again, an important point here is that the Real Estate Commission does not fine licensees, typical licensees, I should say, or firms or anything like that. The only people they can fine, and certainly have done so, are the timeshare developers. Definitely we'll see questions on that, quiz questions, exam questions, in terms of the do's and don'ts, or cans and cannots of the Real Estate Commission. Remember that timeshares, they're the ones that can be slapped on the wrist. In fact, I realize now as well, looking ahead at your next slide here, I just asked you the question that you were going to ask our audience. Let's go ahead and look at that again.
Let's take a look.
To, reiterate, just give them that quiz question.
Yeah. So let's see, true or false. A North Carolina broker fails to share the public offering statement with a potential timeshare purchaser prior to showing 3 separate timeshare units. The North Carolina Real Estate Commission may fine the developer $1,500 for this action. Now, again, there's a lot going on. There's a little bit going on here. What I would probably do is I would fall in love with the fact that the money added up. The money makes
sense. You're like 5, 10, 15.
Like 5 times 3 is 15. Add a couple zeros. Yeah. But the problem is, I've used this question a lot over the years, is what is actually a violation and what is not. And remember, it becomes a violation if you don't share it prior to contract formation. So in this case, the question says they failed to share the offering statement prior to showing 3 separate timeshare units. Well, I know from experience, you show in the timeshare business, you show a lot of timeshares because your timeshares love to give free stuff away to get people in the door. Right. And so you're going to be showing a lot of them, but you probably show 30 different 30 different units for every contract you sign. Right. So it's not a problem to show the units. It's a problem to go under contract without sharing the offering statement. So I'm going to say this is going to be a false, right? The offering statement must be shared prior to contract formation, not prior to showing it. Showing it's all fun and games and happy, enjoy the moment. But when it comes to money changing hands and someone committing to a contract, we have to share the offering statement before they're committing to the contract.
This kind of reminds me of the requirements of having to present the residential property disclosures and the oil, mineral, gas rights disclosures prior to a potential buyer submitting an offer. Isn't that similar here?
It is, absolutely. Very good example. And in fact, there's a 3-day rescission period for the RPODs and the MOG if you fail to disclose that. So absolutely, like always, the Real Estate Commission's focus is, and these laws that correlate, they are focused on consumer protection, consumer advocacy. And so absolutely, the Real Estate Commission does not exist to protect developers and to protect timeshare salespeople. No. They exist to protect the consumer. And you can go on with, I show a few videos about timeshares in 303. There's lots of information out there on Google and YouTube. You can do your own research on timeshares, whether or not it's a good investment, bad investment, happy time, sad time, whatever. So yeah, their job, I like to say it's almost like a Dante's Inferno thing. There's kind of a special level of real estate law for timeshare developers. They get their own set of rules because they've hurt a lot of feelings over the years. Yeah. A lot of people have gotten miffed at them because one of the big problems people have with timeshares is they can be difficult to sell. And even though you may pay the thing off, you're stuck paying the annual or quarterly maintenance fees. And yeah, it can lead to some hurt feelings.
You mentioned rescission period again. While we're here, let's recap the options for rescission periods, right?
Sure.
So we've got a 3-day rescission period, which again applies to what scenario?
The failure to share the residential property disclosure or the mineral, oil, and gas disclosure prior to contract formation.
All right.
There's
Then
a
we've got
7-day.
5 that you just talked about, 5-day rescission period involving timeshares.
Yep, you got it.
All right. And then 7 you mentioned earlier as well, applying to what?
Condominiums, purchasing a new, keep an eye on, again, the adjectives matter. Is it a new condo or is it a resale condo? Where I live and where you live, there's not that many new condos, but there certainly were in the 80s when the law was passed. And so nowadays, you probably are seeing more new condos in Raleigh or maybe downtown Wilmington or Charlotte. But the idea of the 7-day rescission period was to protect people who were buying these new condos at the beach or these new condos at a mountain resort, because a lot of times they realized on their way home from their little weekend getaway that how are we going to do this? How are we going to afford this? We can't afford another $1,100 a month expense. So if it's purchasing a condo, they had that 7-day period to change their mind.
Yeah. What about a townhouse?
Ooh, I love it. That one came up in my class last night. Townhouse is a 0-day rescission period because there's no law. I'm like, does that mean every timeshare developer is well behaved? No, it just means that the state legislature never passed a law to protect townhouse purchasers. They did pass a law for condos, they passed a law for timeshares, but townhomes, there is no built-in automatic protection. Now, you could certainly negotiate a due diligence period if you're buying a townhouse, but you don't get a automatic, give me all my money back, get out of jail free card that you would for new timeshares and new condos.
All right, cool. Well, thanks for taking that sidebar with me. I thought it was an important fact here. Again, with the throwing out of so many numbers to our audience, the 3s, the 5s, the 7s, keeping all those straight, it's definitely worthwhile. All right. Well, I believe that wraps up our content for now. I think we're going to move into more of a kind of a review, right? So
Q&A time.
Fantastic. Lead us off.
Rapid fire. So this one always stumps people. I'm always surprised. It seems easy to me, but of course I've seen it multiple times over 5 years, but a lot of people struggle with this one. The North Carolina Real Estate Commission may, after a hearing, take disciplinary action against a North Carolina licensee who has done what? Now, anytime you see Roman numerals, that means it could be more than one, right? Now, on your test, it'll be A, B, C, and D, but occasionally they'll list out Roman numerals, and they might, A might be all of the above, B might be 2 and 3, C might be none of the above. So when you see these Roman numerals, it could be 1, it could be 2, it could be both, it could be none of them, right? And so take a moment and see which one of these could the Real Estate Commission, after a hearing, I like the after a hearing, take disciplinary action against.
Well, I mean, Roman numeral 1 sounds obvious, right? They violated any of those provisions, anything that we've talked about in this series.
You're a violator at that point.
You're a violator, right? But now you're bringing in another state with Roman numeral 2 options. So I'm paused there. Been disciplined by the South Carolina Real Estate Commission.
I had a student one time say, and this just goes to say, it's just kind of practice and analytical and critical thinking. They said, there's no way the South Carolina Real Estate Commission could take away your North Carolina real estate license. And I said, well, that's not what's happening here, right? The South Carolina Real Estate Commission could take away your South Carolina real estate license. You, of course, would have to report that to the North Carolina Real Estate Commission within 60 days, just like you would a criminal conviction. And then after a hearing, the North Carolina Real Estate Commission says, do what now? You lost your license because of fraud, because you defrauded a seller. Let's talk about that. Why don't you come on up to Navajo Trail across from the Denny's on Wake Forest Road, off Wake Forest Road, and let's talk about it. And after I have my day in the hearing, and by the way, you're allowed to have legal you're encouraged to have your own attorney present for that hearing. After the hearing, the North Carolina Real Estate Commission may say, yeah, if if you were bad enough to get your license revoked by South Carolina, we're going to go ahead and say, we don't want you to have a North Carolina license either. And so it's actually going to be both of these guys. It's not that South Carolina has the power to discipline your North Carolina license. It's that if they disciplined your South Carolina license, then the North Carolina Real Estate Commission may say, yeah, we want to talk to you and we may discipline you as well. And that could be as simple as, well, the North Carolina Board of Appraisers disciplined me, or the Virginia Board of General Contractors disciplined me. So anytime I am disciplined by another licensing board, whether it's this state or another state, I have a duty to share that with the North Carolina Real Estate Commission. And then it's in their hands and they can decide, well, it's not that big of a deal, no further action needed. Or they may say, we need you to come to Raleigh and sit for a hearing and tell us your side of the story. And they may decide to discipline me, or they may decide to just let it roll off at that point.
Yeah, again, in the interest of protecting the consumers.
Yeah,
And anything, there's consumers in South Carolina too.
yeah.
So anything
That's true.
Discipline there should be considered here. All right, so the answer to this is both. So if we were to see a multiple choice question that says 1 and 2, that would be the correct answer.
You got it.
All right.
All right. Let's rapid fire another one here. A real estate license. This one will get you. I love this one because people fixate on just the date and they fail to pay attention to the wording of the question. A real estate license must be renewed no later than every what? Now, remember, we said June is a big deal. June is a big deal. It's Jason's birthday month. That's right. It's my anniversary. It's usually one of the happiest months for most Americans. Someone told me that one time, like it's one of the happier months. Everyone's like, yay, it's June, right? And so one of these days, well, first of all, anniversary of licensure, that no longer matters. That used to be a thing with post licensing, but that's pretty much gone away. C, December 31st, well, that's New Year's Eve, right? It's a fun day, but doesn't matter with regards to your real estate license. So it's going to come down, and that's good strategy. Sometimes you can just kind of rule out all the throwaway answers. A's a throwaway answer, C's a throwaway. It's going to boil down to either B or D. And a lot of people will see June 10th and think that's it, because June 10th is a significant date. Indeed. But Jason, what do you have to do? You of all people should know what's due on June 10th.
You know, before I started this role as the director of the school, I used to take that week off every year, that week in June every year, because it was my birthday. But now I can't, because it's such a significant date to schools, because that's when you are required to have your required CE completed by. June 10th is the CE, or continuing education deadline, for the CE year. So not the renewal deadline, but the educational requirement, the specific CE requirement. June 30th, therefore, is the last day to renew your license.
Yep. Remember what action triggers what. If you have to do your CE by June 10th, that will make your license active for the following fiscal year. And you must renew your license. You must pay the currency to keep your license current, and that must be done on June 30th. So usually when I do this live in class, it's usually about 30 to 40% of the class picks B, because they just fixate on June. They're like, oh, it's June 10th. That's got to be it. No, you got to pay attention to what they're actually asking you here.
Yeah, and I like to remind students that real estate typically is on a July 1st calendar, meaning our January 1st is July 1st, really. If you think about it, the license year is a July 1st through June 30th calendar year. And so, therefore, at the end of our year, things are due, or things need to be renewed, like your license, things like that. So
it always gets me that we're in Q3 right now. We're in Q3 for the Real Estate Commission. And I'm like, wait a minute, it's March. How is this Q3?
Quarter one in the calendar, right?
Yeah, exactly. Their Q1 is July, August, September. And so, yeah, we're not far away from the end of the year for the real estate commission. We're about 3.5 months away from the end of their fiscal year. And I heard this, I think it's true, that most cities and counties and towns in North Carolina also operate on a fiscal year that's July 1st to June 30th. So who knows? I won't bring up the bail bondsman example again, but every industry or every licensing thing besides real estate, they have their own fiscal years. A lot of them probably mirror what we have, but they can set it up the way they want.
Sure.
All right. So in North Carolina, all real estate brokers must do what? Let's see. Let's go look at our options here. Do we all have to maintain a trust account? Thank goodness, no. In fact, even real estate firms and real estate broker in charges like me and like you, I don't have a trust account. Jason, do you have a trust account?
No, sir.
All right, good for you. So no, it's definitely not A. Do we all have to belong to the local board of realtors? No. Jason's a realtor. I am between realtor memberships right now. I've been a realtor of about 4 different, well, you're always a North Carolina realtor. If you become a realtor, you're always a national, but you also join the local association. And at the moment, I'm not a member of any local association. So I'd say no, we don't have to be realtors. Do we have to complete? And this one gets a lot of people. Here's another good example. Pay attention to the wording. A lot of people pick C here. Complete continuing education each year in order to keep their license current. Now, some of our brightest and best students will say C, and they're like, what do you mean it's not C? It's C, right? It says, look, I know I got to do my CE each year. You already said that.
Yeah.
And I'm like, you're right, you do. But there's one little word that makes this wrong, and that is current. You must complete your CE each year in order to keep the license active. Right. So I'm like, yeah, it's 90% right, but 10%, well, 70% right, 30% wrong. And unfortunately, 70 is not a passing score. And then D, include, here's the blind ad reference, include the firm's name and advertisements of a client's property. There's your answer. That's why I always say, keep reading, right? Don't fall in love with the first answer that sounds right, because you might keep going and find one that you're like, oh no, that is it. We just talked about that a little while ago, and that is definitely the case. So we're going to say, to avoid a blind ad, keep your firm's name in the advertisements.
And I'll say too, another argument to see, Rob, could be the term each year, because as new licensees strike out into the industry, they most likely will not have to complete CE until their second year.
That's true. Second license renewal period.
Right. So
I always say you get the first June for free. You get
June.
the first June off. Well, not for free. You get it free from CE, but you must pay your renewal. I had a buddy got his license on May 28th last year, and like 2 weeks later, he texted me. He's like, "Hey, I don't have to pay my renewal, do I?" I said, "Oh yeah, oh yeah, you do, bro. You made it by 2 days. You got to pay your $45, but the good news is you don't have to do your CE."
Yeah. All right.
All right. What else do we got here? We got, how many days does a provisional, it's a tough one. How many days does a provisional broker have to deposit earnest money? Well, earnest money, trust monies in general are tricky. First thing you got to ask yourself, and I'm going to overlook the obvious here for just a sec and say it would normally depend on whether or not it was cash or if it was something other than cash. If it's something other than cash, a broker would normally have 3 days from contract formation. However, this particular broker is a provisional broker. And of course, a provisional broker, I sometimes refer to that as the training wheels. They still have the training wheels on, so they cannot handle earnest money. They are required to immediately turn it over to their broker in charge, right? If this was a non-provisional broker, that would, of course, change the scenario. But I'm going to say, because they are provisional, they're expected to immediately turn it over to their BIC.
Very good.
All right, another challenge here, true or false. Any financial institution holding trust funds for a real estate broker must make their records available to the real estate commission for inspection purposes. Now, this one always kind of made me laugh because I thought, how are you going to tell the bank what to do? Like Jason and I can't tell the bank what to do. And you know what the real estate commission would say? Find another bank. If your bank's not willing to turn over their records for inspection purposes, find another bank, right? And so there's your solution. Find a bank. Can't be a, by the way, it can't be a credit union. Needs to be a bank or savings and loan institution lawfully doing business in North Carolina that's FDIC insured. They also must be willing to make their records available. I always looked at it this way. I could make my records say pretty much anything I want. I could make my records my personal records show that I've got $300,000 in my trust account. But if the real estate commission audited me and my records say 300,000 and the bank's records say 180,000, ooh, that's not a good look for me, right? And so they need to be able to see both my trust account records and the bank's records to make sure that my records are accurate, that I'm actually telling the truth.
Right.
Because
From the
people have
source.
gotten a lot, exactly. People have gotten in pretty serious trouble, including losing their license for commingling trust funds. So it's pretty serious business. So I'm going to say that's going to be true.
True.
You got it. All right. Let's meet Joanne. She's a broker of Go Realty, and she's showing houses to her client. They look at 10 houses before he asks to see one that is listed with Go Realty. On his written, again, the adjectives matter, written buyer agency agreement, he declined dual agency. Can Joanne go ahead and show him a house listed with Go Realty? I'm afraid not, because once you have a written buyer agency agreement, once it's in writing, if you decline dual agency, Joanne cannot show you that property until you amend or create a new buyer agency agreement in which you do accept dual agency. So once buyer agency is in writing, the dual agency consent matters a great deal, right? If it's in writing and this person said, I will not do dual agency, then I can't show you a property listed by my company until we revisit that agency agreement. She may, after she obtains written authority from both the buyer and the seller, to act as a dual agent in this case.
Yeah, and this is where students may think, oh, well, they're only showing the house, so it's okay, right? We're not talking about putting an offer in yet, which of course then you would want to have dual agency agreed upon. But yeah, it's got to be done prior to even showing the home that's listed with the same firm. So
yep, you got it. Once there's a written buyer agency agreement, a sneaky little sidebar is if Joanne and this buyer just have an oral agreement, nothing's in writing, then she would just need his oral permission to proceed. But once it's in writing, if he said no in writing, then she cannot proceed until that is modified, amended, whatever you want to do there. But once it's in writing, that's pretty sacred. And, some people may say, no, I'm not going to do dual agency. I want exclusive representation. And so there it is. All right, true or false? The offer to purchase and contract addresses the seller's remedy for breach of contract by the buyer. That is going to be true, right? It explains the forfeiture of earnest money if a buyer breaches the contract and other options beyond earnest money, right? So as you can see from our challenge at the end here, you can expect to see on the state portion of your PSI exam, you can expect to see questions from pretty much almost any other chapter in the book or any other unit in the book. But you can expect to see a lot of questions on the state PSI exam from the license law stuff that we've looked at, but also a lot of stuff from Unit 7, which is the laws of agency, Unit 8, which are agency agreements, Unit 9, which is contract law, Unit 10, which is the offer to purchase. So I always try to warn people, don't think that it's only going to be license law on the state exam. They're going to ask you questions about other stuff as well, such as the offer to purchase, what's on the offer to purchase, what's not on the offer to purchase. And so got a lot of studying to do there.
Yeah.
Joanne's back. She's a PB with Go Realty. Therefore, she cannot work as a designated dual agent with David Bennett, who's also a provisional broker of Go Realty. Well, the thing is, there are some limitations on provisional brokers with regards to who they can be designated against. If Jason is my broker in charge and I'm a provisional broker, we cannot be designated dual agents in the same transaction. But a PB versus a PB, that's fine. A provisional broker versus a full broker, that is fine. A full broker versus a broker in charge, that is fine. But remember, a provisional broker cannot go head to head against their broker in charge. She could not be designated opposite her own broker in charge, or of course, anyone from another firm. Remember, dual agency always means there's one firm involved. If there's more than one firm, it's not dual agency.
Yeah, and think about the reasons why behind this, right? As far as what's not allowed, a PB and that PB's BIC going head to head, right? Well, if you go back to what the BIC is in place for primarily, and that is to supervise and guide their, the training wheels, as you say, their provisional broker. You can't necessarily do that and help your client over here win the deal as well, right?
Right.
Is that essentially why they can't do that?
Correct. They're the lifeline, right? If the Joanne gets in trouble, she's going to call her broker in charge, and her broker in charge is going to say, "Wait a minute, I'm on the other guy's team.
Yeah,
I'm on the Red Sox. You're
sorry,
on the
I can't help
Yankees.
you.
I'm on the Red Sox.
Yeah,
Sorry."
that's the last thing a BIC can say. Sorry, I can't help you.
Yeah. So it's a conflict of interest. And so not a big deal. We can work it out. They could both, by the way, work as dual agents, remembering that dual agents means that they're both neutral. They're both essentially referees instead of advocates. So they could be dual agents, or Joanne could refer this to somebody else, another person within the firm, and be paid a referral fee for that situation. So I'd ask your broker in charge how they want to proceed there. All right. The major two requirements in North Carolina, speaking of Unit 8 here, in North Carolina, for area to be considered finished heated square footage. I like to say there's three, but one of the three is finished. When I say finished, I say walls, floors, and ceiling, right? You can't count a cement floor typically. You usually can't count, exposed brick walls, for example, with a few exceptions. So a finished is one of them. The other two will be permanent heat source and accessible from other heated square footage. So it needs to be finished. It needs to have a permanent heat source. So my electric heater in my garage won't count. Actually got an electric heater on my back deck now too. So I've doubled up, and but neither one of them could count, right? Because neither one of them has permanent heat source, and neither one of them's finished, right? They're both accessible from other heated square footage, but you need all three. So watch out for terms like a detached workshop or a unfinished bonus room. Stuff like that does not count as part of the heated square footage of your property.
We also see this as living square footage.
Yep.
In terms of other ways of, you might see it in test questions: finished heated square footage, living square footage.
Oh, nice. Yeah, good point. And people get in trouble for this, unfortunately, somewhat often, because they'll count an unfinished basement, or they'll count an unheated basement, or a detached bonus room over let's say you've got a detached garage with a bonus room over the top, and that bonus room is finished and it's permanently heated. But guess what? It's not accessible from other heated square footage. We like to say it still has value. You can still put that in the remarks. Hey, this property also boasts a 600 square foot finished heated bonus room over the detached garage. It's just not part of the main house measurements, is what I like to say. So I'd probably call that 2,000 heated square footage for the house with an additional 600 square feet detached bonus room, something like that.
Yeah, and you're emphasizing heat, I noticed. So what about
Yeah.
cooling? Does it have to be cooled?
Yeah, it doesn't have to be cooled. As crazy as that sounds, they didn't take my vote on that. They didn't poll me. I'd say air conditioning, but it's just heated. It's just heated, and so I guess that one's probably been on the books for a while. I'm old enough to remember, and if you spend time in the mountains, actually there are places up there. I stayed in a house last summer that didn't have air conditioning. And so it's hard to believe, but yeah, they're out there. A lot of places, certainly on the West Coast, near the Pacific Ocean, you'll find properties that don't have air conditioning. And in the high enough up in the North Carolina mountains, you'll find properties that don't have air conditioning. They arguably don't need them because it doesn't get above 80 and gets down in the 50s at night. So you're absolutely right. It does not have to be air conditioned.
All right.
All right, let's hit another true or false here. As the seller's agent, you are required, proofreading time, you're required to verify the accuracy of title charges on the settlement statement. I've always hated this question because title charges is so vague, but essentially what they mean by title charges are the attorney's fees, like the title search, the recording of the deed, that type of thing. And so those are not paid by the seller, right? Pretty much the only thing the seller's paying at closing traditionally would be commissions. They're paying excise tax. They're paying deed preparation, but they don't pay for the recording of the deed and they don't pay for the title search. And so this is going to be false. This would fall under the buyer broker's responsibility. Seller's agent is proofreading, as I like to say, excise tax, due diligence, other items that will affect the seller financially. So remember, you proofread your client's information, right? That's your job. Your job is not to look out for everybody on the settlement statement, but certainly your people. And you might find yourself as a dual agent someday where it is your job to proofread seller and buyer side, but that's somewhat rare these days. All right, two parties to a contract. We have two parties agree that a breaching party will pay the other party an agreed upon monetary amount. This sounds like what? Well, again, this is a Unit 9 contract law question. You could ask the same question in law school because it really has two answers. From a law school's perspective, we would call that liquidated damages. Specifically on the offer to purchase contract, it is earnest money. So liquidated damages can apply throughout contract law. For our contract, specifically, that is typically earnest money. Earnest money deposit serves as the liquidated damages. If a buyer breaches the contract, they will then forfeit their earnest money, make it worth the seller's while, make it worth their while. So speaking of, right, don't just fall in love with license law. This comes straight out of Unit 17. When calculating a property management operating budget, what is never included? So really what we're talking about here is how would one calculate the net operating income? And essentially what you do is you take the income and you subtract all of the expenses except for debt service, aka mortgage, right? So you would take the income, you'd subtract the cost of maintenance, the cost of utilities, the cost of property taxes, all your other annual costs, but you do not factor in debt service when it comes to the operating budget. True or false? All North Carolina agency agreements, listing buyers, etc., must include the broker's license number and an anti-discrimination clause. You got it. They do, right? There's a few things that always have to be on agency agreements. We need the signature of all parties. We need an expiration date. We need the broker's license number, and we need that anti-discrimination clause, which you can find on any association of realtors agency agreements. It just says We refuse to participate in any type of discrimination based on any of the 7 protected classes. True or false? Ooh, 2, the number 2. If I see the number 2, I'm naturally suspicious. Brokers are required to retain the WWREA for 2 years. False. Pretty much the only time 2 years will kick in is if we're talking about experience needed to be a broker in charge. 2 years full-time experience. Brokers must retain the WWREA along with all their transaction stuff for 3 years. 3 years from the conclusion of the transaction.
Right. Not just that disclosure, but all records pertaining to that transaction. Good.
100%. You got it. So speaking of, let's talk first substantial contact. Which scenario best demonstrates first substantial contact? Let's see. A buyer says they like the school district. Yeah, so do I. So does Jason. So does our friend Gerald. Everybody likes the school district. It's rated really well. That's not first substantial contact. Seller states they hope to sell within 6 months. Well, I see a lot of students latch onto that one because it's the first good, not even good answer, but the first like slightly decent answer. Look, they hope to sell within 6 months. You know, I mean, that could apply to a lot of people in a lot of situations. So I'm going to keep going and see if I see one that better demonstrates first substantial.
Right.
Number 3, seller states they must relocate within 2 months. Maybe they're moving for a job. Maybe they have to take care of a loved one. That looks mighty good if you're asking me for best example of first substantial. Let me look at number 4 just to make sure it doesn't knock it out. Buyer shares their desire for 3 full baths. Well, I want 3 full baths as well.
Sure.
In fact, I'll take 5 full baths if I can. I'm never going to have too many full baths. So I'm going to say 3. If Jason must relocate within 2 months for a job or to care for a loved one, that is the best example of first substantial. When you're thinking first substantial, think about information that could be used against you so that the other party could potentially use that as a negotiating piece. And so I say 3 all the way there.
Yeah, because if you knew that I was desperate enough to be somewhere within 2 months, you could use that against me if I were a potential buyer.
Absolutely. Absolutely. Totally. All right. True or false? This one gets tricky. A dual agent may disclose confidential information about their seller client to other brokers working for the firm. Now, when people hear this, I don't blame them for saying, no way, it's confidential. Old car, keep it to yourself. But the answer is sort of you could, because guess what? If Jason and I are both dual agents, we're both referees. And I always say it like this. If you watch, there's not much American football on nowadays, but there is American basketball. And you might be watching March Madness, which happens to be started yesterday. You'll occasionally see the referees, those annoying referees, blow their whistle. They all get together and they have a little chat, right? They're like, hey, Jason, what did you see? Hey, Rob, what did you see? Hey, Tiffany, what did you see? And we all 3 get together and I'm like, well, I saw that dude grab that guy's shirt and pull him down. You're like, I saw the same thing. Okay, well, we're going to call a foul on Mr. Shirt Grabber over there. So as a dual agent, we're all on the same team. There's really not confidential information. Keep in mind that would not apply to designated dual agency, but it would apply to dual agency. So I'm going to say it's okay, but you might want to tell them to shut it. You might say, listen, don't tell me that, because I may end up with a client who's interested. And if you tell me too much, it might prevent us from working as designated dual agents. So while it's legally possible, it may not be in our best interest. So tough question there.
Yeah, perfectly illustrated though. Very good.
Yeah, the old referee one always gets them. So, all right, especially during football season. True or false? A broker property manager in North Carolina can deposit. Oh, I love this one. And I'll tell you let me tell you the question first. And I'll give you the best opposition I ever got to this, and it was good opposition.
All right.
True or false? A broker property manager in North Carolina can deposit rent checks directly into the bank account of the property owner. So I had a student, and she was 100% right. She just kind of misjudged it. She said, well, listen there, Skippy, my property manager direct deposits my money every month into my account. And I was like, you're right, they do. I used to do that too. Guess what they do first, though? They take the rent they collect from the tenants and they deposit it. They legally have to deposit it into their trust account, right? So that it's accounted for, so that it would show up in a real estate commission audit. And then they pay you. They pay you from their trust account. They can either pay you via check or they can pay you via direct deposit, but they're not legally allowed to just take that rent and dump it right into your account. First of all, they want to make sure they get paid. So they're going to take that rent, put it in their trust account, pay themselves and pay you. And so they must, all rents collected must go into, on behalf of others, that is, must go into a trust account. And then the property manager will pay the owner from the proceeds of that account. And I think of it as, look, I used to collect a lot of rent. There was a time when I was collecting hundreds of thousands of dollars in rent each month. And, you know, as much as my boss loved me, he was terrified that I was going to rob him. And so, you know, if you're collecting $300,000 in rent each month, I'd be nervous too, right? And so they want to make sure that all that money is accounted for. And if the real estate commission were to audit me, they can see, all right, this is exactly what was collected. And this was exactly, as far as collected from the tenant, and this is exactly what was paid out. Because you could have a dishonest property manager collecting rent from tenants and saying, I never got it. Well, we'll know if you got it because it'll be documented in your trust account. So it's for the best.
So property owners should think about it as receiving proceeds, not rent.
There you go.
The rent's got to be processed, and then whatever's left over is the proceeds. Similar to residential real estate commissions that have to go through the BIC, being the property manager in this case. And then whatever the firm split is, they'll take that before giving you the proceeds of that commission. So good way to look at it. All right.
Net proceeds. We have the gross rent collected and the net proceeds paid to the property owner. Solid. Yeah. All right, true or false? At closing, a North Carolina buyer's agent in a residential, here we go again with our proofreading, is expected to verify that the settlement entries reflect the terms of the sales contract and all amendments between the parties. Let's say, yeah. In fact, I'd say the same is true of a seller's agent. If you're looking at the settlement entries that reflect the terms of the sales contract and all amendments, look, pretty much everything that's agreed to as far as contract, amendments, that's fair game for both parties. You're talking about offering price, due diligence fees, earnest monies, any other amendments. Yes, I'm going to say that would apply to all buyer's agents and seller's agents, because that's our job. It's our job to know the contracts, not necessarily our job to be waist deep in the buyer's financial side of things, to know what their discount points are, to know what their origination fees are, but it is our job to know the contract. The contract is our baby. That's our responsibility.
Something I, you know, as far as with real estate agents that I work for in my firm, new ones, anyway, this is the biggest thing that I push to them. Like, you've got to know, like, the back of your hand, these contracts and what they say. And I love opportunities when a question is asked and the answer is in the contract. And, you know, we're able to say, well, actually, the answer is in your contract. So you tell me, in the interest of teaching them to fish rather than just giving them the fish.
Absolutely. Absolutely. It's in the contract. Find your own answer. Like, think of it as an exciting scavenger hunt. True or false? A dual agent representing a seller is not permitted to share material facts about the condition of the property with the buyer. Now, most people will catch this one here. You start to think, well, you know, I do want to keep certain things confidential. I don't want to just go around with a big mouth blabbing a blab, blab, blab. But material facts, they got to be shared, right? If there's a leaking roof, or if it's a short sale, or if there is a highway construction nearby that's going to impact the property, all agents, buyer side, seller side, property manager, tenant representation, whatever, are required to share all material facts that you either know about or should be able to know about.
Right. And Rob, correct me if I'm wrong, but what I think a lot of students do wrong here on an exam question like this is they'll see an answer option that says, yeah, we must disclose all material facts when asked.
Oh, yeah.
Right, as compared to to all potential buyer, we must disclose all material facts to all potential buyers prior to submitting an offer. In addition to when asked, if it's something specific. But in other words, you're not waiting to volunteer this information selectively. You are required to disclose those regardless of being asked or not.
Right. That's an excellent point. You don't wait for someone to ask you, right? If you know that there's an issue, the seller's in a short sale, which of course is a situation where the seller owes more than the property is likely to sell for. You don't wait until, well, they never asked me, right? That's a material fact, which means, the buyer may run away from that situation depending on their needs. They may rightfully run away from it. And so you, with the material fact, you have to voluntarily put that information out there, think of it as like a public service, right? You're like, hey, I have a duty to share this, because it could have a huge impact on the desirability of this property for you. Maybe someone else won't affect them at all, but it could affect you dramatically. So I have a duty to share it.
Yeah, and this is where, licensees feel like they're in conflict with their duties to their client and the duties to the licensing law. Basically, this is one of those times where you feel like you're abusing the relationship with you and your client by disclosing something that they've told you, hey, I don't want you to mention, that water stain on the roof there, or the ceiling, I should say. And, and again, that's where we feel like we're in a little bit of a rub there.
Right. Definitely. It's the higher law wins that one, right? Right. You're like, well, yes, I have a fiduciary duty to the client, but ultimately material facts will overrule that fiduciary duty to the client. And I really appreciate that, because there's times when I feel like the fiduciary duty makes it a little bit too much us versus them, good guys, bad guys. But material facts are like the fair play. It's like, hey, look, fair play. There's a roof leak, fair play. There's a highway. Because you buy a house and 2 weeks after you close, you see the DOT show up and start bulldozing trees in your backyard. You're like, thanks for the heads up, guys. I don't think I would have bought this property if I knew 540 was going to be in my backyard. So it's fair is fair. Disclose those material facts.
That's right. All right. Good points.
So a broker, well, I love this because we get to talk about misrepresentation versus omission.
Yeah.
A broker advertises his individual condo unit as having great views of the Cape Fear River, but you can actually only see the river from the rooftop of his building, right? I've seen these. I know these type condos, right? There's some condos downtown, got tons of great condos going up in Wilmington. And but look, you might be able to see the river from the roof of the building, but from my unit, you're looking at a parking lot with an ATM machine, right? And so I'll go ahead and tell you, if I misrepresent my condo as having great views of the Cape Fear River, and I'm the guy who personally owns it, or even if I just know for a fact that that's a daggum lie, that's going to be a willful misrepresentation. Like I said a couple videos ago, listen, it's willful if you know, and we know that you knew, right? There's no doubt, right? The evidence is there that you knew. Well, if it's your individual condo, you've been there before, you know darn well you can't see the Cape Fear River, so it's willful. And it's a misrepresentation if you open your big yapper or you press send. So omission would be just not say anything, which can be a serious problem. But a misrepresentation is arguably worse because you said something was the case and it's clearly not the case. So a misrepresentation, if you open your big yapper and you say that you can see the river when you know for a fact you can't see the river, it's a willful misrepresentation. If a buyer seller client wishes to add unique provisions to the contract that would not be covered by the standard, I should say addenda. That always gets me. Addendums. It's because I'm from North Carolina, Jason. Forgive me.
All right.
Broker should advise the client to do what? Well, we know they could technically write it in themselves, but I don't like that. I'm going to advise them. I'm a professional, even though I can't pluralize addendum. I can give good advice. And the advice is hire an attorney who can draft the addendum for you. Because if you get in front of Judge Judy or Judge Wapner and you're trying to have a contract enforced, you got a much better chance of winning if it's an attorney drafted addendum instead of something you wrote on the back of a cocktail napkin or on the back of a brown paper bag or something like that. So yeah, best advice, hire an attorney.
Hire an attorney.
People don't always like that answer, funny enough, because attorneys are, they don't usually work for free, but still there's a difference between what they like and what the best advice. We don't often like the best advice. True or false, a broker is required to disclose that a property is within a federally recognized flood hazard zone as a material fact to all prospective buyers. Absolutely true, right? That's a big deal. Now, I can't necessarily, people's next question is, how much is the flood insurance? Well, that's between you and your insurance company. And that depends on, I'd start by getting a survey, right? And find out how big how much of the property is impacted, then talk to your insurance company. I can't quote you prices, but I can go online, as can anybody, and find out if any part of the property is impacted by a flood hazard zone. This one's close to your heart, is it not, Jason?
Yeah. Yeah. Yes, I was relieved to sell my last property because of how much my flood hazard insurance had increased to. So
did it ever actually flood when you lived there? Did you ever have any damage?
Nope.
Right.
That's the insurance game for you. You pay, but if you don't use it, you don't get anything out of it, basically. But yeah.
All right. True or false? Speaking of, we just saw this, the only pre-printed sales contracts that brokers are allowed to use in the great state of North Carolina is that standard form 2T drafted by your friends at NCAR, North Carolina Association of Realtors. It's false, right? Like I said, when I worked for a development company, and you yourselves may someday be involved in a new homes transaction, or you may be involved in a purchasing property directly from a developer, that's not the only contract. It can be pretty much any attorney drafted contract that meets the standards of the Real Estate Commission. It's just going to need important details like legal property description, manner of payment, etc. So remember, it's not a one-horse town. There can be other contracts. In fact, there are probably, if you added them all up, there's hundreds of contracts used throughout the state, if not thousands, for the sale of real estate. But of course, if you're a realtor, you can use the realtor contract. If you're not, then you need to find another avenue there.
Yes. Keywords there are optional. And again, they're not the only ones that we can use. So good to read.
Got it. Another square footage question. To be considered heated living area, a room must have a minimum ceiling height of 7 feet. And when measuring sloping ceilings, we stop at 5 feet. These are both true, right? It's interesting because I guess somehow Americans are getting taller over the years. I sometimes wonder if I had lived in like the 1700s, I might have been like a professional basketball player. But ceilings get higher and higher, right? And so if a house is old enough, you may encounter this with a house that was built in the 1800s, that they might have ceiling height. Some rooms may not meet that minimum 7 feet. So the ceiling height needs to be a minimum of 7 feet. And if you're measuring, and you see this a lot, it's kind of the reticularly, I forget the exact scientific word for it, but when you get involved with trying to sell a property with sloping ceilings, you start noticing it more often. And my parents' house has sloping ceilings because it's a story and a half. So sloping ceilings become a big issue when you're trying to measure a property that's 1.5 stories, because you have the first floor and then the second floor is approximately half the size of the first floor because the walls slope. And so that's something you're probably going to run into fairly soon in your career as a real estate broker, is either sloping ceilings with a finished attic or a 1.5 story, something like that. Essentially, you can only count. You have to stop counting as far as the width of the room once you hit the 5-foot mark on the slope ceiling there.
Right. Two another important numbers when it comes to square footage measurements, 7 and 5.
They'll sneak them in there on you. True or false? A licensed appraiser must have an active broker's license to manage real property for another person.
Oh, so you're
and
the
answer,
a couple of different terms here, a couple of different positions.
Yeah, right, exactly. And so the thing is, a licensed appraiser can go do appraisals all day, enjoy yourself, have fun, knock yourself out. But if they're crossing over into real estate brokerage, which managing real property for others is in fact brokerage, you are a love doctor at that point, then that's true. That's true. Just because you're an appraiser doesn't mean you're also a real estate broker. Same thing with attorneys. Some people are like, well, some people fall for that on a test question. They're like, well, wait a minute, if they're attorney, can they also work with buyers and sellers? No. Can they do certain things like work as a trustee or a guardian? Yes. But an attorney passing the bar exam does not automatically make you a real estate broker. Passing your appraiser's exam does not automatically make you a real estate broker. There are plenty of people who do participate in both fields, appraisal and brokerage, but they're two separate fields, two separate licenses.
Perfect.
You still thinking about getting your appraiser's license, Jason?
Yeah, I think it'd be a great supplement.
Yeah, I do too. True or false? A licensed real estate broker may draft a loan contingency addendum for their buyer.
Stop you already. I would just stop you.
I'm like, I couldn't even get through the first 4 words.
Stop you. Why? Because of that word draft.
The only drafts I want are draft beer, and that's about it. That is it. Other than draft beer, I stop there. So that's of course false. You need an attorney to do the drafting. Attorneys, race car drivers, and bartenders. That's about it.
Yeah, that's it.
Speaking of our friends, the material facts, we only got a couple more of these, y'all, so hang tight. Material facts relating directly to the property, such as a scheduled road expansion. Hey, you see those trees behind your house? Those are going to be a highway pretty soon. That must be disclosed to. Classic example of people who fall in love with number 2. Don't fall in love with number 2. No. We know it's not no one. But what if someone asks? If they ask, I have to tell them. I have to tell them, right? Yes, you do. But it's not just the people who ask.
Right.
It is all prospective buyers, right? Because a lot of people aren't going to know to ask. So keep in mind, material facts, all prospective buyers.
Fantastic.
All right. And I think that's actually the last one I have. So I have emptied the chamber here. That's it. and so, Jason, is there anything you'd like to add on top of that?
No, I think that was a very good and in-depth review. Again, if you just joined us for this one particular video, there are 3 more that precede this one. So a total series of 4 videos that, again, breaks down the licensing law and rules comments. Revisit this particular area in your textbook. It's also accessible if by chance you're not a student of ours. Of course, you can travel to the North Carolina Real Estate website, North Carolina Real Estate Commission's website, that is. It's ncrec.gov. And in the educational area, you will find, again, a PDF document that essentially outlines this same content. Again, North Carolina license law and rules comments. Big section of what you're going to be tested on, again, in both the course and in the state licensing exams. So we hope that you guys found this helpful. I suspect, Rob, will probably be breaking down some other topics and units in future videos, right? So
Sure.
it's only the beginning, but we wanted to start with this all important area of content because it, again, is a third of your exam. Super important, especially as you earn your license and go out into the world practicing. You got to know these licensing laws and the rules. So, Rob, thank you for your time and efforts here. We appreciate it. On behalf of the Go School, thank you guys for watching. If we can answer any questions, clarify anything, if you'd like to reach out to Rob or myself, simply utilize the email address info@goschool.biz. Again, info@goschool.biz, and I'll make sure that we direct your question to the right person and or Rob. And again, if you guys need anything, let us know. Rob, thanks again, buddy. We will see you next time.
All right. Thanks a lot.